Weekly list item number 17.
Yes, month. I'll vote your lordship. After that, if your lordship will kindly permit me. Okay, just tell us that it's a single appellant. Single appellant. So 302 life imprisonment. Again. Okay. And this is this one Subhadra Patra. Yes, yes. Come to the charge that is at page 32. So date of occurrence is 29th August 98. 98 at 4 p.m. Place is Molar, Baga, Bodojoro, Nola. I'm sorry, my lord. The time of occurrence is 1:30. We are looking at the charge that it is. The charge is 4 p.m. The occurrence took place situated in village Garsara. Committed murder of Subhadra Patra, wife of Prafulla Patra. Wife of man, his own wife. Own wife. Okay, so deceased is Subhadra Patra, wife of Papalan. Date of occurrence on 29/8/1998. Okay, now you come to the first information report. Let us see. Milord. Your lordship will kindly permit me. FIR. Tikeshwar Patra examined. Tikeshwar Patra examined PW2. Yes. In fact, my lord, the learned trial court. Yes. The learned trial court has relied on evidence of. Come to read the evidence of. Page 30. मोर नाम टिकेश्वर पात्र, बयस 50, पिता घासी पात्र. Your lordship got it, page 30. Yes, yes. पढ़ंतु आजिता 29/8/98 शनिवार उपरबेला 4टा समय सरसरा ग्राम बसंत साथी ग्राम रखी बसंत कुमार नायक साथी PW13 ओके टिकायतपल्ली थाना रे हाजर होई बणाई सर्कल इन्स्पेक्टर बाबू उनको आगरे ए मौखिक रिपोर्ट करूछि कि आज दिन 2टा बेले मु घरे थिली सेते बेले मोर बंशीकिया भाई नाथ पात्र नॉट एग्जामिन इज दिस डेड आसी कहिला तार ज्वाई प्रफुल्ल तार झियो को आगे अपलान झियो को चाकुरे भूसी मर्डर कर देछि सुभद्रा के स्लो करो सेते बेले मोर बंशीकिया भाई नाथ पात्र आसी कहला तार ज्वाई माने नाथ पात्र ज्वाई तार झियो माने नाथ पात्र झियो को चाकुरे भूसी मर्डर कर देछि आज्ञा आज्ञा ओके ठीक है। सुभद्रा बड़ जोर नाल पाख
ମଲାର ବାସରେ ମରି ପଡ଼ିଛି। ତାପରେ ମୁଁ ମଲାର ବାସକୁ ଗଲି ଓ ଦେଖିଲି ମୋର ଝିଆରୀ ମଲାର ଯାଇ ପାଣି ନାଳରେ ପଡ଼ିଛି।
କଣ ହେଇଛି? ଝିଆରୀ କୋଉଠି ଆସିଲା?
ମୋର ପଢି ହଉନି।
ମଲାର ବାସକୁ ଗଲି ଓ ଦେଖିଲି ମୋର ବଡ ଝିଅ ଲେଖିଛି, ତାମାନେ ଇଏ ତାର ଝିଅ ମାନେ ବୋଧେ ଇଏ ଆର ଝିଅ କି?
ନାଇଁ ନାଇଁ, ସେ ନାଥର ଝିଅ।
ଆଚ୍ଛା, ଯାଉ ସୁଭଦ୍ରାକୁ ପାଣି ନାଳରେ
ମରି ପଡ଼ିଛି। ତାର ଡାହାଣ ପାଖ ପେଟ ଭୂଷା ଆଘାତ ଚିହ୍ନ ଅଛି, ରକ୍ତ ବାହାରୁଛି। ସେଠାରେ ବହୁତ ଲୋକ ଜମା ହୋଇଛନ୍ତି। ଆମ୍ଭ ଗାଁର କୁନ୍ତି ପାତ୍ର, ରେବତୀ ପାତ୍ର, ଆଜ୍ଞା
ରେବତୀ ପାତ୍ର
5 ମିନତି ପାତ୍ର ନଟ୍ ଏକ୍ସାମିନ୍ କୁ ପଚାରିବାରୁ କହିଲେ, ଆଜି ଦିନ ପ୍ରାୟ 1:30 ବେଳକୁ ଶ୍ରୀଭତ୍ସ ପାତ୍ରଙ୍କ ବିଲରେ ଘାସ ବାଛୁଥିଲୁ। ହଠାତ୍ ମାରିଦେଲା ଆବାଜ ଶୁଣି ଠିଆ ହୋଇ ପଛକୁ ବୁଲି ଦେଖିଲୁ ପ୍ରଫୁଲ୍ଲ ପାତ୍ର ସୁଭଦ୍ରାକୁ ଗୋଟିଏ ଚାକୁରେ ଭୁଷିଦେଲା। ଆଜ୍ଞା, ସୁଭଦ୍ରା ପାଣି ନାଳରେ ପଡିଥିଲା। ହଲ୍ଲା କରି ଘଟଣା ଜାଗାକୁ ଦୌଡ଼ି ଗଲା ବେଳେ ପ୍ରଫୁଲ୍ଲ ପାତ୍ର ଚାକୁ ଧରି
ଜଙ୍ଗଲ
ଆଡକୁ ପଳାଇଗଲା। ସୁଭଦ୍ରା ନାଳରେ ମରି ପଡିଛି, ତାର ପେଟରେ ଭୂଷା ଆଘାତ ଅଛି। ଲୋକ କହିବାରୁ ମୁଁ ବସନ୍ତ ସାଥିରେ ଥାନାକୁ ଆସିଲି। ବସନ୍ତ ହାଜ୍ ବିନ୍ ଏକ୍ସାମିନ୍ଡ PW13 ମିଲଟ। ଥାନାରେ ଆସିଲି। ଗତ 3 ବର୍ଷ ତଳେ ସୁଭଦ୍ରା ପାତ୍ର ଆମ ଗାଁ ପ୍ରଫୁଲ୍ଲ ପାତ୍ରକୁ ସ୍ୱଇଚ୍ଛାରେ ବାହା ହୋଇ ଏକାଠି ରହୁଥିଲେ। ପ୍ରଫୁଲ୍ଲ ମଝିରେ ସୁଭଦ୍ରାକୁ ମାରପିଟ କରୁଥିଲା। ଗତ ବୁଧବାର ସକାଳେ ପ୍ରଫୁଲ୍ଲ ସୁଭଦ୍ରାକୁ ମାରପିଟ କରିବାରୁ ସେ ତାର ବାପା ନାଥ ପାତ୍ର ଘରକୁ ପଳାଇ ଆସିଥିଲା ଏବଂ ମାରପିଟ ବିଷୟରେ ଗାଁ ସେକ୍ରେଟାରୀ ଲିଙ୍ଗରାଜ ପାତ୍ରଙ୍କୁ ଜଣାଇଥିଲା। He has been examined. ଆଜ୍ଞା, ଆଜି ମୋର ବଡ ଝିଅ ସୁଭଦ୍ରା,
ବଡ ଝିଅ ତ କହୁଛି ଆଉ ନାହିଁ କଣ
ସିଏ କହୁଛି, ବଟ୍
ଝିଆରୀ
ସେ ଝିଆରୀକୁ ଝିଅ କହୁଛି।
ଆଚ୍ଛା, ହଉ ଠିକ ଅଛି।
ସୁଭଦ୍ରା ବଡ ଜୋର ନାଳକୁ ଝାଡା ଯିବା ବେଳେ ପ୍ରଫୁଲ୍ଲ ପାତ୍ର ତାର ପିଛା କରି ଚାକୁରେ ଭୁଷି ସୁଭଦ୍ରାକୁ ମର୍ଡର କରିଛି। ଏଣୁ ଏହାର ବିଚାର କରାଯାଉ। ଲେଖି ପଢି ଶୁଣାଇ ଦେବାରେ ମୋର କହିବା ମୁତାବକ ଲେଖାଥିବା ଠିକ ଜାଣି ମୋର ଦସ୍ତଖତ ଦେଲି। ଏକବିତା
that means there are eyewitnesses to the occurrence.
No eyewitness. 4 and 5.
What are the eyewitnesses?
PW4 and 5.
PW4 and PW5. So the one item is eyewitnesses account of witnesses, right?
Again.
What are the other materials?
Other material is, my lord, confessional statement leading to discovery of that MO1.
That is PW 6
and 11.
Leading to discovery of what? That
Of a
knife. Or knife and knife of knife. Seta ki
PW6.
IO?
IO is PW14.
PW14.
Doctor PW8.
Doctor is PW8.
IO ta hala PW14. 6 ta hala independent witness.
PW11 भी say जो seizure of the discovery of witness, but hostile is.
PW11 hostile कर लेते हैं। अच्छा, एक गोटे आइटम वाला आई विटनेस, गोटे आइटम वाला लीडिंग टू डिस्कवरी। आउ कौन अच्छी?
PW8 वाला PM.
अच्छा, डॉक्टर
PW8.
PM डॉक्टर PW8. अच्छा, that is the evidence.
Again.
So if the assault was by knife, let us go to that doctor's evidence.
Exactly. That is most important.
PW8
page 63.
Page number
63.
PW8 PM doctor.
On 3898, I was working as assistant surgeon at subdivisional Bonai. On that day, on police requisition, I held autopsy over the dead body of the deceased Subhadra Patra, wife of Prafulla Patra of village Sarsara, PS Tikayatpalli, district Sundargarh, being identified by C853B R Bhoi and one GR Basant Naik, and found the following. On external examination, she was average built, body built, eye closed, face pale, rigor mortis disappeared. This is most important, my lord. External wounds, stab wound size 5 cm into 2 cm into 7 cm on right side of abdomen, grievous in nature, oblique in direction. In B, inside wound 2 centimeter, 1 centimeter below right breast, simple in nature. These two external injuries were found. Internal examination, the stab wound was directed oblique upwards and penetrated right side liver. Muscle and peritoneum below the wound was cut. Abdomen was filled with clotted blood. The margin of the wound showed gapping. Liver was pale and penetrated. Spleen and kidney pale. Heart contracted, both chambers empty. Right lungs and left lungs were pale. Presence of bleeding and gapping of margin of wound indicate that both the wounds were antemortem in nature. Cause of death, death is due to hemorrhage, shock resulting from stab wound. Next paragraph, my lord. Time since death is more than 36 hours. Just here I will point out, my lord, this postmortem was conducted at 11:30 the next day. This postmortem was conducted at 11:30 on 38/98. The timing is important, my lord.
Yes.
Time since death is more than 36 hours, as rigor mortis have passed off. My postmortem examination. This is the PM examination report, which is marked as Exhibit 8, and Exhibit 8/1 is my signature thereon. On 10/9/98, on police requisition and query made by IU, I have examined the weapon of offense, that is one knife having length 9.5 centimeter approximately and handle length of 11 centimeter. Length of the blade 18.5 centimeter approximately, blade 30 centimeter, one edge is sharp and other edge is blunt, and replied the query of the police is follows. Query 1. The injury can be caused by the knife produced before me. Query 2. Injury number 1, that is stab wound, can cause death of a person in ordinary course of nature. The said weapon was brought by Prabhat Kumar, ASI Tikayatpalli, PS, and returned to him with seal, which was affixed with my signature after examination. This is the said weapon opinion report, which is now marked Exhibit 9 and Exhibit 9(1), my signature thereon. I can identify the said offense, a said weapon of offense, that is knife, if it is shown to me. On being shown to him, he correctly identified the MO1, which was sent to him by the police for examination. My signature has been affixed on the handle portion of the weapon on a paper. On dissection, I found cross-examination part. On dissection, I found one wound, that is stab wound. The same is penetrated structure below its obliquely. The internal injury corresponding to the external injury number 1. There was no corresponding to the external injury number 2, as the same was simple in nature. Injury number 2 can be possible by fall in a rocky substance, as the same was incised in nature. The injury may be possible if somebody falls on a sharp object of similar size of the wound, like broken glass or any other sharp object of that type. Both the injuries can be caused by MO1. The size of external injury number 1 is more than the width of the MO1. The size of the external injury 2 is lesser than the size of the MO1. I have not mentioned the time since death of the deceased in my postmortem examination, that is Exhibit 8. Exact time of death cannot be ascertained, as rigor mortis has passed of the time since death is more than 36 hours. Liver is a vital organ. Chance of survival is remote. Built in well-equipped institution having highly skilled surgical facilities, if immediate treatment had been given to the patient, might have survived. The MO1 which was brought to me by the police was only affixed with a label paper on its blade of one side with writing. I have not sealed the MO1. I will, with any wrapper. I have put my designation seal on MO1 with the signature on a paper label, and that is the only seal which I have put on the MO1. The inquest report is at Exhibit 3, does not bear my signature seal. It is not a fact that Exhibit 3 was not sent to me at the time of conducting post-mortem examination. It is not a fact that I have prepared Exhibit 8 and 9 at the instance of the IO. This is, my lord, the doctor.
So what is your submission?
My lord, first part is, my lord, the postmortem was conducted 22 hours after, as per the prosecution story, my lord. And here he says
11:30
again 11:30
PM report avar karo. Mark into exhibit
again.
11:30 AM.
Again 11:30 AM, my lord, postmortem was conducted.
Yes.
And death, as per prosecution story, is at 1:30, between 1 and 2. So, my lord, postmortem was conducted before 22 hours, after 22 hours only. And possibility of absence of rigor mortis is impossible in that case, my lord. Rigor mortis have passed off.
Rigor mortis जोटा कहूची
Again.
rigor mortis रो केतेबेले appear करिवो केतेबेले pass off करिवो, that is there is no straitjacket formula.
Exactly.
It depends upon the climate, it depends upon the age of the person. से किछि नाही जे गोटे सबु circumstance रे सबु situation रे सबु age group रो गोटे एवं सबु मासे रे माने
Your lordship is correct.
winter ये होउची सब गुडाको
खरा दिने आज्ञा टिके शीत दिने टाइम बेसी लागिवो, खरा दिने कम.
rigor mortis रो
That is
just
my lord. It has been explained in
209.
Modi's medical jurisprudence.
हमने मेडिकल jurisprudence होती है राइट आउट नहीं से चैप्टर जो पेज रे देइछि Handle. हाँ ये एडोबेट मार्क करो ये from 6 hours of the day trigger motor starts stiffness turbulence, but it also depends upon the weather condition. It is wrong to say that contraction is found in the body all day. See the zero you can is mentioned in 125. ତାକୁ ପୁରୁଣା ବହିଟା ଆଣିବ ମୁତିର ହେଲା ଏଟା ନାହିଁ toxicology edition number so and so. In general, rigor mortis sets in 1 to 2 hours after death is well developed from head to foot. In 12 hours, धीरे धीरे लेकिन stiffness आसियो 12 घंटा is maintained for about 12 hours. ହେଲା ସେଟା maintain ହେଇ ରହିବ. Then passes of in about 12 hours. In the intervals present in the lower swanso at the time of autopsy was conducted swanso after 30 hours. According to the ocular testimony, murder or not about swanso, and the doctor conducted autopsy over the dead body next day, that is after 30 hours, but the rigor mortis was found present at the diet swanso, the past of completely at the time of transfer. Because the ocular treatment that was murdered and transfer overrated from the medical audit, pinpointing that it was in this one. But the food particles, rigor mortis are eguda wrong. The କହିଦେଲ ପୁରୁଣା ସେଟା କାହିଁ ତା ଦେହରେ ହଁ ତ ପେଜଟା ଦେଇଛି କିନ୍ତୁ ତା ଦେହରେ ନାହିଁ ସେଇ ପେଜ ପଛପଟେ ଦେଇଥିଲା ପୁରୁଣା ବହିରେ ପୁରା କ୍ଲିୟରଲି ଅଛି ରହିଛି। Sunday. This report is summary report. Mohammed Firoz versus State of MP, 2022, 7.
Modi जी
The basic principle of restorative justice development, the maximum bonus now open.
मोदी जी
देख देख देखिए
राइट हैंड लेफ्ट हैंड साइड मतलब लास्ट पर
ସେଟା ଉଠିନି ତ ଉଠିନି କି କୋର୍ଟ ବି ଡାଇରେକ୍ଟ କି ମାନେ ଆର୍ଗୁମେଣ୍ଟ କରିନି କିଛି explain
2008 column 16, SCC 582.
is a slave
Doctor
ନାଇଁ ସେଇଟା
another into reverse direction, that is from right to left, taking up an angle to allow. On this basis, when we examine the body of the on the rigor mortis side, reverse almost to the end of the day. But this way we come to conclusion that it must have offered about 39 hours before.
But here, in right hand side, my lord, regarding the, it will be brought to the doctor, my lord.
କଣ ହେଇଛି? If this doubt regarding the time of death is reasonable, then the prosecution case should fall on the grounds that our include the fact that it took
that is para 6. The judgment which your lordship is reading, I will the copy. Para 6. In para 6, that judgment which your lordship is reading, that I have given the copy.
Which one?
That is
Yeah, 2002.
Justice Hegde.
It is not in your compilation.
No, I got it today. In compilation, I have given a recent judgment. That is page 14.
On this issue.
Exactly this issue. Page 14, if your lordship will.
No.
It's a 2023 judgment.
How long today does rigor stay set in? Question has been put. Rigor mortis approximately appears 2 hours after death in the muscles of the face. The upuru start progresses to the limbs over the next few hours, compelling between 6 to 8 hours per day. Rigor mortis then stays for another 12 hours. 12 ଘଣ୍ଟାରୁ ତାପରେ disappear. Then what is the three stages of rigor mortis? Rigor mortis have been most well known. Swan solution is a process by which body muscles stiffen, resulting rigidity as a result of variety chemical changes in the muscle structure. Okay, then sit for that. Rigor mortis or postmortem rigidity is the fourth stage of the death. It is one of the recognizable signs of death characterized by stiffening of limbs caused by chemical changes in the muscles. Postmortem in humans, rigor mortis can occur as soon as 4 hours after the death. Compared to swans, rigor mortis is not permanent, begins to pass within hours of onset. Typically, it lasts no longer than 8 hours of the temperature. After death, swans on point of Physical changes. All the muscles of the body undergo this process. Rigor mortis starts from the neck. Hala? The eyelids proceeds to the jaw, lasts for 2 to 6 hours post-death. The mentioned sequence could be correlated to the differing levels of lactic swans or muscles, which can be but notice usually peaks after 12 hours, lowers in that's 48 hours. So see that is his main problem. The, uh, if you food digestion, here rigor mortis ଗୁଡାକ that is some actually say like the region is at this point 24 apartment to no.
In page 14 of my note, your lordship, that is a judgment of 2023.
We are not going to the judgment.
Again.
What the doctor has stated that time of death is more than 36 hours as rigor mortis.
Again.
As rigor, see, reason ta douchi je whether in medical science it can be the sole factor, because when we are seeing that rigor mortis କେତେବେଳେ appear କରିବ କେତେବେଳେ pass off କରିବ ଏଟା ଗୋଟେ କିଛି straight jacket formula ନାହିଁ. It depends upon several factors.
Exactly.
ଆପଣ କୋଉଠି body ଟାକୁ ରଖାଯାଇଛି ବା body ଟା କୋଉ ଜାଗାରେ ମିଳିଲା, ତାକୁ postmortem ହବା ପୂର୍ବରୁ କୋଉଠି ରଖାଗଲା, ये सबू जिनस अच्छा वेदर कौन रही
आज्ञा
हाँ गोटे कथा तापरे को एरिया रे मध्य हेछि माने आपनकर गरम
शिमला की राजस्थान
हिल स्टेशन ये सबू बतेर बहुत पार्थक्य रही ता
बट योर लॉर्डशिप इज आस्किंग
नाला भितर पड़तला
हाँ
बट योर लॉर्डशिप इज आस्किंग to that account, my lord, I am referring my page 14 of the judgment exactly reflects that. It says, my lord, it says that, my lord, unnatural situation, it is the duty of the prosecution to explain as to why, my lord, in the present case, as to why, my lord, rigor mortis has passed off, even though death is only of 20 hours. That has never been explained. And the judgment said it is the duty of the court also to ask the specific question. That is the judgment which I have given to your lordship. That part was never dealt with.
But suppose you are unable to dislodge the evidence of the two eyewitnesses, right?
Again.
And we also find that the version of the eyewitness, let us assume that eyewitnesses account that the deceased was assaulted by knife. The doctor has also found knife injury, stab injury, and it is obliquely upwards. तामने ए टाइप रो सेटा पूरा ହେଇଛି ହେଲା ତେଣୁ upward ଯାଇଛି ଏବଂ ଦିଟା ଆଉ ଗୋଟେ ଆର ବ୍ଲୋଟା stabbing ନୁହେଁ but inside stone ଇଏ ହେଇଛି, and that is the cause of death. So when the ocular evidence is clear, trustworthy, suppose medical evidence is somehow contrary. Contrary means it is not that it is not possible, that injury is not possible. So injury is possible by knife. About the time of death which you are telling, so the witnesses, have they stated exactly when the occurrence took place?
1 to 2
specific
गोटाए रु दुईटा भितर जणे कहिछि गोटाए 30 आज्ञा this is the specific.
So let us say it is stated after noon, माने noon 12 noon परे घटनाटा हेछि, right? तेणु आपणकर कहवा कथा जे जदि पोस्टमार्टम टा हैला 11:30 रे तेणु एटा 24 घंटा भीतर आसुची
आगे
तेणु 24 घंटा भीतर आसिले एटी स्टिफनेस थांता किछि कारण स्टिफनेस टा स्टार्ट कंप्लीटली ही जाए 12 घंटा बेलू पूरा आरंभ
आगे
आउ 12 घंटा सेटा रहे
आगे
24 घंटा पर तापर धीरे
Recession
धीरे
आरंभ।
धीरे धीरे पास ऑफ होई जाए एटी पास ऑफ हेई जाइथिला
पूरा complete।
दैट मींस सेति पई से कहउछंती जे एटा 30 घंटा पूर्व 36 घंटा पूर्वरु मु जेतेबेले पोस्टमार्टम करिछि तार 36 घंटा पूर्वर ये डेथ कथा if that is accepted then the ocular version that the occurrence took place at about 1 o'clock or 2 o'clock that is not acceptable maybe that the occurrence has taken place prior to that and nobody has seen and the dead body was found in that nala and after at about 1 o'clock or 2 o'clock and they saw it that dead body and then they might be implicating that who else would be the author of the crime. It is the husband who had gone some dispute. They might have
again
already. But these are all things which once we accept the version of we just dislodge the evidence completely.
again
That the eyewitnesses account is would the medical evidence would prevail over the but there is no such
hard and
you
fast.
will find that all the decision says that medical evidence the opinion of is an expert opinion right
again
it is 45 evidence act law it's if it is an expert opinion then it is said that the court is expert of expert hala tenu doctors evidence से खाली गोटे दउची जे स्टिफनेस पास करची तेणु एटा 36 घंटा पूर्वर केस तेणु एक्सपर्ट एविडेंस गोटे साइड रे रहिबो आरो साइड रे कंसिस्टेंट ऑकुलर टेस्टिमोनी रहिबो जोटा को आपण डिसलॉज करिवेनी पारिवेनी मु गोटे कहिछि वी हैव नॉट गॉन थ्रू दैट वी विल सी दैट सो इन सच सर्कमस्टेंसेस वेदर the medical evidence would override the ocular evidence. It is not that possibility of injury कहूनी माने मन को lacerated wound थांता माने नोटिस ही थांता as per the PM report आपनकर विटनेस माने कहउथांते जे ताकू छुरी रे भूसी दला सो स्टाब वुंड नाही आपण डॉक्टर एग्जामिन करी कहि थांता जे नाइ छुरी रे एई इंजुरी पॉसिबल नै so it's completely contrary to the ocular evidence that matter is something different but here is a case where the eyewitnesses account that the injury has been caused by knife is getting corroboration from the medical evidence. Not only that, the knife has been seized, it was sent to the doctor examined and said that this injury is possible. So these are the circumstances. One is eyewitness, two is that postmortem report finding, leave with that rigor mortis. But number three is the leading to discovery of the weapon and possibility of the injury with such weapon which has been opined. सेही सर्कमस्टांस रे खाली गोटे रिगर मर्टिस टा पास ऑफ हे तो एतिकी पाई whether we will disbelieve the entire prosecution case that is the crux of the matter.
Another aspect is because your lordship is going through the doctor's evidence your lordship will mark me lord it is query number 2 injury number 1 because I couldn't find a judgment letter delivered by your lordship that wound can cause death in ordinary course of nature this particular physiology me lord though it is mentioned here but in postmortem report that doesn't find place and that apart me lord if that postmortem report can be taken along with the last paragraph in page 65 of the doctor's evidence the size of external injury shall I read it again
Injury may be possible if somebody falls on a sharp object of similar size.
Again the size of external the last paragraph last 4-5 lines of page 65 exact time of death cannot be ascertained as rigor mortis has passed off time since this one so liver is a vital organ, chance of survival is remote, but in a well-equipped institution having highly skilled surgical facilities, if immediate treatment could have been given, the patient might have survived. This is to be what my contention is. This is to be read with the postmortem report, my lord. I know, my lord, that is a not substantive piece of evidence, but in postmortem report that has never been mentioned.
What has not been mentioned?
That physiology, my lord, the injury can sufficient is in ordinary course of nature to cause death, my lord.
No, that is an aspect that you see, once you go to whether it is a murder or not, then section 300 indicates the 4 clauses where the culpable homicide would amount to murder. And when it would not amount to murder, there are 5 exceptions that has been laid down. So if it comes within any of the clauses, that particular words have been used in clause 3, that the injury must be sufficient in ordinary course of nature if the bodily injury caused and it is, but that is not present in clause number 1, 2 and 4. Right?
Okay.
So if it comes within 1, 2 and 4, and even if the doctor does not say that it is sufficient in ordinary course of nature to cause death, then also it would attract section 300 or it will amount to murder. If it comes within clause 3, then the vital factor is that it should be sufficient in ordinary course of nature cause death. So the doctor has he has made a query. He stated that knife was produced before me and the injury can be caused, and the stab injury can cause death of a person in ordinary course of. These are
Again. But this particular
again you have to see that the part of the body where the assault was made is a vital part of the body, and because the internal examination indicates that the stab wound was directed oblique upwards and penetrated right side of the liver, and muscles peritoneum below the wound was cut and abdomen was filled with swanso. ତେଣୁ ଏଠି ଆପଣଙ୍କର ଏକ୍ସେପସନ ଭିତରକୁ ଆପଣ ଯଦି ସିଆଡକୁ ଡ୍ରାଇଭ କରୁଛନ୍ତି that whether it amount to a 304 part 1 or 304 part 2, because one injury is actually fatal, the other injury, though it's an incised wound, but it has been opined to be simple in nature, right? But you are to bring it case within this any of the exceptions that there was any kind of quarrel or whatever it mentioned in any of the exception. So if it is out of grave and sudden provocation, if it is during quarrel and single blow is given, this matter is different. But I think there is no such evidence here. Whether
the Lordship may kindly come to the evidence of PW 4 and 5. In fact, the genealogy of the assault has never been given.
No, because from the other witnesses there that due to the previous quarrels, there are the president and the secretary of the village.
That is also mentioned in the FIR also.
Yes, ma'am.
Okay.
They called a meeting. On that grounds, in the morning, on the date of meeting, he was murdered in the morning.
नहीं
day hour.
नहीं दिन गोटे
next day ना
हाँ गोटे बेलू
मीटिंग टा हला से कहूची पूरा एठी माने एफआईआर जा स्टोरी होची
again.
हाँ प्रफुल्ल मझिरे मझिरे सुभद्रा को मारपीट करथला एटा पेज 31 पर चारटा 1 2 3 4 5 6 सिक्स्थ लाइन प्रफुल्ल मझिरे मझिरे सुभद्रा को मारपीट करथला गत बुधवार सकाळे प्रफुल्ल सुभद्रा को मारपीट करिवारु से तार बापा नाथ पात्र घर को पळाई आसला ओ मारपीट विषय गाँव सेक्रेटरी लिंगराज पात्र को जणाइथिला आज मोर बड़ झील सुभद्रा बड़ जोर सुआंशो झाड़ा जीवा बेले प्रफुल्ल पात्र तार सुआंशो सो दिस इज द बैकग्राउंड माने इमीडिएटली ए जिंसटा हे आज माने एटा होची जो 29th August of 1998.
28 ରେ ଦେଇଛି କମ୍ପ୍ଲେନ।
ହଁ ମାନେ
that will be clear from the evidence of the PW 3 matter.
PW 9 ରେ ଅଛି।
PW 3 also the secretary matter. Matter.
Secretary was handed over the
ଘଟଣା
complaint by the
ଦିନଟା
president।
ଘଟଣା ଦିନଟା ଥିଲା ଗୁରୁବାର ଦିନ।
ଆଜ୍ଞା
ଦେଖିଛନ୍ତି ତାର
ଗୁରୁବାର ଦେଖିନି।
29/8/1998 ଟା କଣ ଏ ଗୁଗୁଲରେ ମାରିଦେଲେ ଜଣା ପଡିଯିବ ସେଟା କୋଉ ବାର ଥିଲା। କାରଣ ଇଏ କହୁଛି ଯେ ବୁଧବାର ରହୁଛି ଏଇ ଯୋଉ ସକାଳେ ଏଇ ମାରପିଟ ଘଟଣାଟା ହେଇଛି, ତାପରେ ସିଏ ଯାଇଛି ବାପ ଘରକୁ ଯାଇକିନି ଏ ବିଷୟରେ କହିଛି ଗାଁ ସେକ୍ରେଟାରୀକୁ।
29th was Saturday.
ହଁ ଆଚ୍ଛା ସଟରଡେ, ହଁ 29th ସଟରଡେ ରାଇଟ୍। ଘଟଣାଟା କେବେ ହେଇଛି?
ଘଟଣାଟା 29 ରେ।
ତାମାନେ ଏଇଟା ହେଇଛି ବୁଧବାର ଦିନ ଏଇଟା ହେଇଛି, ତାପରେ ଗୁରୁ ଶୁକ୍ର ପାସ୍ କରିଛି, ସାଟରଡେ ହଉଛି ଘଟଣା।
As per the matter PW 3 matter, I'm just reading out the.
Let us come to PW3.
I know the informant of this case. I know the accused standing in the dock. I also know the deceased Subhadra, who was the wife of the accused. The occurrence took place on the day in the year 1998 near Badojoro Malpasa Nala at village Sarsala. At the relevant time, I was the secretary of the community and Arikita Patra, the PW9 Malor, was the president. The deceased Subhadra has given a written complaint alleging that therein that she was being frequently assaulted by the accused. At about 9 a.m. on the date of incident, the president handed over me the said written complaint. On the basis of the said complaint, myself and the president had decided to convey a meeting to decide the matter after 2 days on this issue, but on the same day, the deceased was killed by the accused. On the same day, the police seized the same written complaint from my position and prepared the seizure list, and this is the said seizure list, which is now marked as Exhibit 4, madam, for my signature.
ଯୋଉ ରିଟିନ୍ କମ୍ପ୍ଲେନ୍ ଟା ପ୍ରମାଣ ହେଇଛି?
That is Exhibit 4.
ଆମକୁ ଏକ୍ଜିବିଟ୍ 4 ଟା ହଉଛି ସିଜର ଲିଷ୍ଟ ଟା।
ନାଇଁ ସେ ଯୋଉ ରିଟିନ୍ ଟା ପରା ରିଟିନ୍ ନୋଟ ପ୍ରିପେୟାର କଲେ ସେଟା ସିଜର କଲେ।
The same day the police seized the ସେଟା ସିଜର ଲିଷ୍ଟ ଦେଖିଛ ତା ଦେହରେ ଲେଖା ହେଇଛି ମାନେ
କଣ ଲେଖା ଦେଖିବ
ଏକ୍ଜିବିଟ୍ 4 ଟା।
ଆଜ୍ଞା
ଏକ୍ଜିବିଟ୍ 4 ରେ ସେଇଟା ସିଜ୍ ହେଇଛି।
ସିଜ୍ ହେଇଛି ଦେଖିଲେ ଆଉ।
ହଁ ଯେ ସେଥିରେ କଣ ଲେଖା ହେଇଥିଲା?
Contents thereof was never proved.
The written complaint was never exhibited.
Exhibited, but that was not seizure list was exhibited.
କାଇଁ ଗୋଟେ ଇଏ ଚଲଉଛି ଏଠି?
The written complaint which was seized by the Exhibit 4.
4 again.
Was it exhibited before the trial?
हाँ ହେଇଛି exhibit 4 again. କିନ୍ତୁ but ସେଇଟା
ଏକ୍ଜିବିଟ୍ 4 ଟା ହଉଛି ଏଇଟା ହେଲା ଏକ୍ଜିବିଟ୍ 4 ଏଥିରେ ଏଇଟା ହଉଛି ସିଜର ଲିଷ୍ଟ ରେ ଏଇଟା ହଉଛି ସିଜ୍ କରାଯାଇଛି ମୁତବିର ଆବେଦନ ପତ୍ର ଯେଉଁଟା କି ସେ ସମାଜର ଲୋକଙ୍କୁ ବିଚାର ପାଇଁ ନିବେଦନ କରିଥିଲେ। We are concerned ଯେ କଣ ଥାଏ ଆବେଦନ ପତ୍ରରେ ଲେଖା ହେଇଛି ସେଇଟା ଏକ୍ଜିବିଟ୍ ହେଇଛି କି ନାହିଁ ସେଟା ଏକ୍ଜିବିଟ୍ ଲିଷ୍ଟ ରେ ଦେଖିଲେ ଜଣା ପଡିବ। ସେଟା ଏକ୍ଜିବିଟ୍
4/3
ଏକ୍ଜିବିଟ୍
4/3
4/3
ଆଜ୍ଞା
Written complaint.
ଅଛି ଦେଖିବା କଣ ହେଇଛି 4/3 ଟା ଏଇଟା ତା ଦେହରେ ବିଷୟ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଦୁହିଁଙ୍କ ମଧ୍ୟରେ ଝଗଡା ଗଣ୍ଡଗୋଳ ନିବେଦନର ଅଭିପ୍ରାୟ ହେଇକି ମୁଁ ଶ୍ରୀମତୀ ସୁଭଦ୍ରା ପାତ୍ର ସ୍ୱାମୀ ପ୍ରଫୁଲ୍ଲ ପାତ୍ର ସାକିନ୍ ସ୍ୱାନ୍ ଶୋ ଯେ ଗତ 27/8/98 ଦିନ ମୋର ମା ମତେ କହିଲେ ଝିଅ ଦୁଇଟି ଜଣଙ୍କର ହେଇଛି ମା ଝିଅ ଗଲେ ଏକା ଦିନକୁ ସାରି ଦିଅନ୍ତା ମୋର ଦେହ ଟିକେ ଅସୁସ୍ଥ ଲାଗୁଛି। ମୁଁ କହିଲି ହଁ ଯିବ मूल छुटाई देवा यही समय मोर स्वामी शुणी कहले जी आनी खाई से जाओ आमे खाई ना आमे जाऊ ना तू जा सुविधा घर मु भाविली माँ को देह ठीक नहीं मु जीवी भावी माँ को खंडिए गिना थिला आम घरे गिना खंडी को बाहर करी देवा समय मोर स्वामी खंडिए माने बाड़ी धरी मते पिटिले हाथरू चूड़ी शंखा भांग तंटीरे चिपी ओह्लाई कर मते आगुरी बहुत थर पिटी मारी झगड़ा गंडगोल कर मोर जदि दोष नाई देखुंट मते कौन सी 5 जन सम्मुख विचार करी मते अन्याय अत्याचार कर कौन करी केते सही यार कौन सुविधा ना मु निश्चित माड़ पिट खाई मरीजी मोर जीवन को बहुत बाधा भय पशिगला तेणु आपन कर जोड़ी चरण में प्रार्थना करुच्ची मोर देवा दरखास्त पत्रिका खंडिक पाठ कर सुविचार कले आपण मान चरण में शुणी दरखास्त ते काटिदेवी आउ 10 वर्ष जेल जीवी यही मते भाषण दे अन्य दिन बेकरू टांगिया उठाई देइछंती अच्छा. So this report was presented. It was on 28/8/98. घटनाटा हला केफे तापर दिन
29.
29
was the date of occurrence on 3 FIR. So एटा ता पूर्व दिन ता माने
PW9 को दिया था दिस
PW9 देता PW9 3
handed over it to PW3
PW9 इंटरेस्ट कला PW3
3 on the date of occurrence.
से डिसाइड जहा करूथिला जे हमें भाबिलु गोटे मीटिंग फिटिंग ऑर्गेनाइज करिबु बोली किन देखला तार डेट हैला एटा होची ये. So now let us come to that eyewitness account what they have stated.
PW4
As a cross examination you read it out that PW3's cross examination. Page 48.
I was not examined by the IO. I have not received any written complaint from the deceased.
It is the PW9 the Kolapura.
No, PW3 I am reading.
No, that's all right. But that written complaint was received
by
by
PW9.
PW9. Yes.
Again. After receiving the written complaint from President, I have not talked with deceased Subhadra. Similarly, I have not asked anything to accuse Prafulla. It is not a fact that I have not stated to the IO that at the relevant time, Orokhita Patra was the president of our community and the deceased gave him a written complaint, alleging therein that she was being frequently assaulted by the accused, and that the president handed me the said complaint, and that at about 9 a.m. on the date of incident, and that we both decided to convene a meeting 2 days thereafter.
Police suggest it's not a fact that I have not stated before. It has been proved through the investigating officer.
I'll come to that.
Because of that, he was suggested. 161
confrontation is
page 87 madam.
In fact, that I have not stated.
Confrontation.
Confrontation da.
PW कहते हैं
IO madam page 87 madam. Para 25. 14 PW 14.
PW 14 para
25.
Para 25.
Page 87.
Page 87. Let us go straight to that. Then we'll again return.
Again, it will be page 87, first paragraph.
Page 87. Read it out.
I have examined PW3 Lingaraj Patra, and he has not stated before me that at the relevant time, Orokhita Patra was the president of their community.
Orokhita Patra is that
PW9. It is a fact that he has not stated before me that on the alleged date of incident at about 9 a.m. the president handed him over the written complaint.
तो एटा फर्स्ट टाइम पूछी ता माने कोर्ट रे
आज्ञा आज्ञा
जोटा चीफ एग्जामिनेशन
आज्ञा
फर्स्ट टाइम
आज्ञा
सेदी पई ओके देन तापर कोन हला पढंतु
page 48
Hmm.
on the date I have no direct knowledge about the incident. On the said letter bears the date 28th on the bottom, but I cannot say on which date of incident the complaint was made. The document and register of our community is kept with me. No register is maintained regarding the receipt of any letter or complaint. I cannot show any document about my functioning as secretary of the village community. No document is prepared to be appointed as regards to the president and the secretary. The IO has not seized any document from me in connection with the case. I gave my signature on Exhibit 4 in evening hour. The contents of the seizure list Exhibit 4 was read over and explained to me by the IO. Besides me, Arakita Patra was also present at the time of seizure of the said written complaint. Arakita Patra is the cousin brother of the accused. I cannot say whether there is ill feeling between the accused family and the family of Arakita. It is not a fact that nothing was seized from my possession by the police. This is PW3.
Okay, at this juncture you come to the evidence of PW9
Again.
because it is somewhat
A67.
huh
67. Page.
it has got connection with the evidence of PW9.
Yes.
Again.
Then we'll go to the eyewitness account. Okay, because he is the president and the prosecution
He
case is
received
that
the complaint.
huh?
He received the
received the
complaint.
Right. Hold on. PW9.
I know page 67.
Hold on.
I know the informant of this case. I know the accused standing in the dock. I also know the deceased Subhadra, who is the wife of the deceased. The occurrence took place more than 6 years back. The deceased Subhadra had given me a written complaint about the assault made to her by the accused before one day of the alleged incident. At that time, I was the president of our Patra community and Lingaraj Patra was the secretary. I handed over the said written complaint to PW3 with an instruction to the settle matter about 2 days. Settle the matter after 2 days. The police seized the said written complaint from the possession of PW3 in my presence and prepared the seizure list. Exhibit 4 is the said seizure list already marked as 4/2. Is my signature thereon. This is the said written complaint. Now marked as 4/3. 4/4 is my signature thereon. Cross-examination. I cannot say the scribe of Exhibit 4/3. The deceased Subhadra had not put her LTI in my presence. Exhibit 4/3. The deceased was never made any allegations before the written complaint presented to me. I have not seen any mark of injury on the date when she presented the written complaint. I have not ascertained the truth about the allegations made by the deceased. I have not asked anything the accused after receiving the complaint. I had no direct knowledge about the occurrence. Thereafter, agricultural land situated near the Nala and the canal.
There are
Again, I'm sorry, Miller. Not the land is higher in level than the canal and Bodojor Nala. Bodojor Nala and the canal are not visible to the agriculture land. The width of the Nala is about 10 to 12 feet.
Just a minute. The land is higher in level than the canal. Emane you did घटना डाला canal पकड़े.
Canal.
Because the eyewitness evidence is that there at
On
the
the higher
land,
side.
land
They
they
are
saw the
building. Right. So land टा ଉପରେ ଅଛି
ଉପରେ ଅଛି ନା ଏଟା
ଏବଂ ଏଇଟା ତଳକୁ ଅଛି. So ବଡଜୋଳ ନାଳ and canal are not visible from the agricultural land. Why death of the କାହିଁକି visible ହବନି କାହିଁକି?
ସେ କହୁଛି visible ହବନି.
The wide depth of the Nala is about
2 to 3 feet. There is no direct pathway from Nala to agricultural field. One has to cover 1 kilometer distance to come to the Nala as well as the canal from the land of Srivatsa Patra. This is important, Milord. Again. There are continuous rain when the deceased handed over the written complaint to me for about 7 to 8 days. The sky was covered with cloud. After receipt of Exhibit 4/3, I have not gone to the house of the deceased. At that time, Subhadra was staying at her parents' house since 8 to 10 days prior to the occurrence. Subhadra frequent her visit to her parental house and used to stay 8 to 10 days. I put my signature on Exhibit 4/3 When PW3 handed it to the police, it is not a fact that deceased has not given the written complaint to me.
You see, here also something has been brought out. That is also another factor, that the sky was covered with cloud.
Yeah.
That means, and that was for 7 days. So obviously the weather would be cool there,
I'm obliged, Your Lordship, with that.
right?
I got it.
Okay, now you come to the evidence of PW4.
Page 50. I know the informant of this case. I know the accused standing in the dock. I also know the deceased.
Eyewitness, PW4, page number 50.
Page 50.
There are two eyewitnesses, 4 and 5. Yes.
Actually, their case is that there are 3 eyewitnesses, but they have examined.
One has not supported the prosecution case.
No, he was not examined. He was not examined.
Not examined.
Okay. FIR examine
Again. I know the informant in this case. I know the accused standing in the dock. I also know the deceased, who was the wife of the accused. The occurrence took place more than 6 years back near Malabasra Nala at village Sarsara at about 1 to 2 p.m. At that time, I, along with Rebati Patra and Minati Patra, was weeding out the grass from cultivable land of one Srivatsa Patra. The Malabasa Nala is at a distance of 100 feet from the place where we were working. Hearing the cry of the deceased, Morigala Bua, we rushed to the spot and found that the deceased was lying dead on the spot with profuse bleeding injury on his right side belly, and also found that the accused was running away from the spot, being armed with a knife. The accused fled away towards jungle. Then
the actual blow has
no one seen.
No one said.
No one has seen. କେହି ଦେଖିନାହାନ୍ତି.
Then ଶୁଣିଲା ମରିଗଲା ବୁଆ, ତେଣୁ ଇଏ କଲା ପରେ ଦେଖିଲା ଯେ ଇଏ ପଡିଛି ସେ ଜାଗାରେ ଏବଂ ତାର ଇଞ୍ଜୁରି ଅଛି ରାଇଟ ସାଇଡ ବେଲିରେ.
ଏମାନେ ସେଠି ପହଞ୍ଚିଲା ପରେ ସେ ଦେଖିଲା.
ହଁ ଆଜ୍ଞା. ସେ ଏବଂ accused was running away from the spot. ତା ହାତରେ ଛୁରୀ ଅଛି. ଏଇଟା ହଉଛି ତାଙ୍କର କଥା. 100 ଫୁଟର ଡିଷ୍ଟାନ୍ସ ରେ ସେମାନେ ଥିଲେ. ଏମାନେ ଗୋଟେ ହାୟର ଲେବୁଲ ରେ ଅଛନ୍ତି, ସେଟା ଡିଚ୍ ହେଇକିନି ଇଏଟା ରହୁଛି. Yes. Yes. Next, the accused fled out.
Page 51. This line, my lord. Then we raised alarm. Then our village people came to the spot. Your lordship may just mark the sentence. I will come to that. I am cross-examination of the defense. I am not resident of village Harabeda. One day prior to the alleged incident, I had gone to village Sarsara. My husband had also accompanied with me. For the first time, I was working as a daily laborer. On being asked by my mother, I had gone to weed out the grass. I had no prior acquaintance with the deceased Subhadra. On that day, I was weeding out grass from our own land. The said land is bounded by north our land, south Sadapatra, west Doya Apti, west our land. The Kiari bounded lands are bigger in size than the land where we were weeding grass. The Kiari in which we were doing weeding operation is also big Kiari like other Kiari. I cannot say the seed capacity of each Kiari. I cannot say the distance of the ending point towards the north and west of our land from which we were taking weeding operation. I also cannot say the distance of the ending point where we were taking weeding operation of the Kiari of Sada and Doya. I cannot say whose land situates in the east of the land of Doya Ati. I cannot say whose land situates in the northern side of our land. I cannot say whose land situates adjacent to our land further west of our western side land. I cannot say whose land further situates of the land of Sada. For the first time, I had gone for weeding operation, and in our land is a higher level than the Nola. We were weeding out the grass, having bent down. Our lands were surrounded by ridge. It is not a fact that I have not seen the occurrence. Other boundary tenants are also having ridges around their respective kiari. The nala is visible to our kiari. We have to go to the nala through the land of Sadapatra. We three simultaneously came running to the spot. Our village is at a distance of more than 1.5 kilometers from the nala. Dharmu, Ati, Chakra, Barnayak, Tikeswar, PW2, Tikeswar, Sudam, etc. came to the spot. The said nala is not being used by the villagers at the time at the same situates at a distance place. I cannot say whether deceased Subhadra used to visit the nala for using purpose. Now, but nobody was at the spot by the time of our arrival. It was a rainy season. At the relevant, it was not raining. I have not seen assault on the deceased by the accused. It is not a fact that I have not stated before the IO that hearing the cry of the deceased Morigalabua, we went to the spot. The dead body was lying on the land through which...
Just pause for a moment.
Again.
He has not stated in her...
confusion. This was confronted to IO. IO also replied negatively.
But in 26 of the...
But in... 26. But, Milord, in 161, she has stated. I have verified me.
Good.
This was... IO has wrongly also stated. But if your lordship...
In fact,
she stated. If your lordship will verify 161, your lordship will find it.
And so far, let us come to the end of... Yes.
The learned trial court has also dealt with that part. The dead body was lying on the land through which the rainwater was passing to the nala. It is not a fact that I have not stated to the IO that the
because what has been stated by this witness.
Yeah.
First of all, it was during daytime. Okay, so visibility factor there is no problem. And
though it was cloudy.
So it was just 100 feet away, and the land was in the upper, and that ditch was there, and whatever as it found, she would have stated that I saw the accused assaulting. But what she stated that I only saw this much that is going on. କାରଣ ଯେତେବେଳେ ମୁଁ ପାଟି ଶୁଣିଲି ଆମେ ଦେଖିଲା ବେଳକୁ ଏଇ ସିଚୁଏସନ
ସେଠି ଦେଖିଲି ବୋଲି କହୁନି ସେ ସେଠି ପହଞ୍ଚିକି ଦେଖିଲି ବୋଲି that is the problem Miller.
ତେଣୁ
ଇଏ କହୁଛି 100 feet but other witness says it requires 1 kilometer travel to go to that place.
ନାଇଁ ମାନେ ଆପଣଙ୍କର ଯଦି ନର୍ମାଲ ରୁଟ ରେ ଆପଣ ଆସିବେ ଗୋଟେ ଯୋଉ ରାସ୍ତା ଆପଣ ପଚାରିବେ ଯେ ସେଠିକି ଯିବାକୁ ଗୋଟେ ରାସ୍ତା ତାହେଲେ ତ ରାସ୍ତାଟା କିନ୍ତୁ ଯଦି ଆପଣ ଷ୍ଟ୍ରେଟ ତେଣୁ ଗୋଟେ ଜାଗାକୁ ରାସ୍ତା ହେଇଥିବ ହୁଏତ କିନ୍ତୁ ଆପଣ ଯଦି ସିଧା ପଳେଇବେ ବିଲରୁ ବିଚ୍ କୁ ଖସିବେ ଦୌଡ଼ିକି ନେଇକି ଯିବେ ତାହେଲେ ସେଇଟା ହୁଏତ ନର୍ମାଲ ରାସ୍ତା ହେଇନଥିବ ବଟ୍ ଡିଷ୍ଟାନ୍ସ ଇଜ ଜଷ୍ଟ 100 feet ସେଇଟା ସେ କହୁଛନ୍ତି.
No, was it suggested to her that it is more than that, not 100 feet? No,
there is no खाली 100 feet ବୋଲି
ସିଏ ତାର ଚିଫ ଏକ୍ସାମିନେସନ ହିଁ ହଉଛି 100 feet. The Malbara
ଅଲଗା ୱିଟନେସ୍ ଇଏରେ କିଛି କ୍ୟୁବିଟ୍ ଆଣିଛନ୍ତି ଏକ୍ସଟ୍ରା କ୍ୟୁବିଟ୍ ଡିଷ୍ଟାନ୍ସ ଟା. So far it is for
two aspects I will draw
here, my lord. The another thing that he stated it is not a fact.
Dead body was found at that place, my lord. Apart from this witness,
other witnesses it found was reached on the spot.
Acha.
And other witness also reached there. I also
ତ ଚାରିଟା ବେଳେ ଏଫଆଇଆର ହେଲା ସେ ସନ୍ଧ୍ୟାବେଳେ
spot dead body
and this spot
that means the occurrence took place at this particular place. That is not dispute. That's what I inquest भी सही जगह सही जगह रू dead body जाइए postmortem ପାଇଁ. So the place, the spot is not disputed.
No dispute.
Now the question is that unless you bring something from the evidence of these witnesses, one witness you have already placed,
again.
that her presence at the spot is doubtful feature, or his conduct is such that it's a doubt because his name or name finds place in the FIR as an eyewitness. She has stated how the occurrence has taken
Yes,
place.
he also stated that for the first time
Hmm.
she went
to the land for voting.
land
No,
for
that's-
she had come
ଆପଣ
to
ଯଦି
that village.
entirely ଦେଖିବେ ଆଜ୍ଞା with other witnesses, your lordship will also doubt this witness. I will come to that, my lord.
No. ସିଏ ତାକୁ ସେଦିନ ସିଏ ଯାଇଥିଲା ଘାସ ବାଛିବା ପାଇଁ।
ଆଜ୍ଞା।
ତ ଆପଣ ମାନେ କଣ କି ସେ ଯଦି ଘାସ ବାଛିବ ତା ଦେହରେ improbability feature ଟା କଣ ଅଛି? ଆଗରୁ
particular
ଯାଇନଥିଲା ବୋଲି ସେ କଣ ଘାସ ବାଛିବାକୁ
No,
ଯିବ?
no, that I am not that.
Then-
If a lordship will assess the evidence in entirety,
Huh.
this witness PW5, PW13, PW11,
No,
your
no.
lordship will find.
ଗାଁର ବାସିନ୍ଦା ଏଟା କଣ proceedings to assume. I'm not
ନାଇଁ,
resident.
ସିଏ
of
ସେ
village,
ଗାଁର
but
ବାସିନ୍ଦା
on
ନୁହଁ।
that on one day prior to the alleged incident, I had gone to that village.
ସେ ଗୋଟେ part ଖାଲି I have not.
My husband had also accompanied me. For the first time, I was working as a daily labor. So, you know, daily labor is a ପ୍ରଥମ
ସେଟା ଏଟା
ଗାଁର resident.
what your lordship is asking, that has been clarified by court.
Hmm.
In fact, she was bidding in her own land. ସେ ତା ବାପର ଜାଗା ସେଟା।
ବାପାର ଜାଗା
ଆଜ୍ଞା।
ସେ
That
ଗାଁକୁ
was-
ସେ ପ୍ରଥମ ଯାଇଥିଲା
ପ୍ରଥମ
ତା ସ୍ୱାମୀ
ଆଜ୍ଞା।
ସାଙ୍ଗରେ।
ସେ ପ୍ରଥମ
ଯୋଉ
ୱେଡିଂ
ଦିନ ତା
ଅପରେସନ ରେ
ପୂର୍ବ
ଯାଇଛି।
ଦିନ ସେ ଗାଁକୁ ଯାଇଥିଲା ସେ।
ଗାଁକୁ ମାନେ ସେ ଯୋଉ ଜମିକୁ ଯାଇଥିବ।
ଜମି ଜାଗାକୁ ଯାଇଥିଲା।
ଏଠିକି ଆସ।
ହଁ, ବିଡିଂ ଅପରେସନ କୁ ଫାଷ୍ଟ ଯାଇଛି। For the first time I was
Village
working as
so-and-so.
daily.
One day prior to the alleged incident, I had gone to village so-and-so.
That's another.
My lord, kindly come to the page 53 to clarify, sir. Next page, my lord.
Next page ରେ ସେଟା
To
clarify.
quote, the deceased Subhadra is my co-villager.
Yes.
I, along with my husband, have been staying in my parents' house since the time of our marriage in order to look after the agriculture
Of my father.
of my father. Srivastava Patra is my father.
ତାରି ଜମିକି ଯାଇଥିଲେ ଘାସ
ଆଜ୍ଞା,
ବାଛିବାକୁ।
ତା ନିଜ ଜାଗା।
And if you my lord, come to the page 91, the spot map, my lord, there also the indicates the spot and the land which they are wedding, my lord. Shivacha,
Yes.
that is the land where they are wedding, my lord. And the spot is that the जो चिन्ह करछन्ती तीर मारिकी जमीन आळाटा and the side of dead body type of चिन्हटा करछन्ती
ବୁଦ୍ଧିଆ ଜଙ୍ଗଲ।
ଜଙ୍ଗଲଟା ବାଁ ପଟ ହେଲା।
Again, there is another ବଡ ପୋଲ ନାଳ। ମନ୍ଦାର ବାସ ବଡ ପୋଲ ନାଳ।
ସେଇଟା ଏଠି ଆଡେ
ଏଠୁ ଆସି ଏଟା ମିଶିଛି ଏଥିରେ।
ଏଠି
ଜମିରୁ-
ଡେଡ୍ ବଡିଟା ଏଠି ମିଳିଛି। ସେମାନେ ଏଇଠି ଚାଷ କରୁଥିଲେ, ଏଇ ଯୋଉ ସେ ଘାସ ଉପାଡୁଥିଲେ, ଏଇଠି ହିଁ ତାର ଡେଡ୍ ବଡିଟା ମିଳେ। ଦିସ୍ ଇଜ ଦି ଡିଷ୍ଟାନ୍ସ ସେ କହୁଛନ୍ତି 100 feet ହବ ଯୋଉଠି ସେ କରୁଥିଲେ। ଯୋଉ କଣ୍ଟ୍ରାଡିକ୍ସନ ଆପଣ ଆଣିଛନ୍ତି ପ୍ରମାଣ କରେଇଛନ୍ତି, ସେଇଟାକୁ ଯଦି ବି
ଆଉ ଗୋଟେ contradiction ଆଣିଛନ୍ତି, it is not a fact that I have not stated to the IO that the accused ran away from the spot being armed with the knife.
ନାଇଁ, ସେଇଟା ଟିକେ ଆଜ୍ଞା
ସେଟା ଟିକେ 161
ପେଜ ନମ୍ବର 87 ରେ
ଆଜ୍ଞା
ଆଜ୍ଞା ଯୋଉଟା ଅଛି ଆପଣ ଯୋଉଟା କନଫ୍ରଣ୍ଟେସନ କରିଛନ୍ତି
26
87
para.
past paragraph 26
ଆଜ୍ଞା।
please place it, let us see.
I have examined PW4 Kunti Patra, and she has not stated before me that hearing the cry of the deceased Morigali Bua, they went to the spot. She has also not stated before me that the deceased was lying in pool of blood, and she has also not stated before me that they raised alarm and thereafter the villagers came to the spot. She has also not stated before me that the accused ran away from the spot being armed with a knife. In fact, my lord, problem is she has already stated in his 161.
Then
I have
this is
verified it,
that
my
is
lord.
the problem. The session judge, we are repeatedly asking the session judge that when a confrontation is made,
You should go to the
he should himself look at the କାରଣ ବହୁତ ସମୟରେ କଣ ହୁଏ କି ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର ମାନେ ଚିଫ ଏକ୍ସାମିନେସନ କରିଦେଲେ ସିଏ
My lord.
ସେଠି ରହନ୍ତିନି, ସେ ଅନ୍ୟ କଣ
ଆଜ୍ଞା।
ପଳେଇ ଯାଆନ୍ତି। ଇଏ ତାର
ସିଏ ଆଉ ତାକୁ ଦେଖନ୍ତେ
ମାନେ ସେ ତାର ପଚାରି ଦେଇ ଚାଲି ଯାଉଥିବ ସେସନ ଜଜ
କେବେ ସେ ଏକ୍ସାମିନ କରିଥିବ
ସେସନ ନାଇଁ ସେ
ଫାଇଲ ବି ଦେଖାନ୍ତି
ୱିଟନେସ କୁ ଯୋଉ କନଫ୍ରଣ୍ଟ କରନ୍ତି ତାପରେ ମେକାନିକାଲି ତାକୁ ଯଦି ମାଇନ୍ୟୁଟଲି
ନ
ସେସନ
ପଢିଲେ ଏଣ୍ଟାର ନ ପଢିକି
statement ଟା confrontation
ପେଜ 14 ଟା ଦେଖନ୍ତୁ your lordship.
confrontation over rule
allow କରିବା କଥା।
ନାଇଁ 161 ତ ସେ ଦେଖିବ 161
ପେଜ 14 ଟା your lordship may kindly
ଡିଲ୍ କରୁଛନ୍ତି but at the time of the cross
ସେଇଟା ସେ
court should not allow the
right it should not have been allowed
page 14 your lordship may kindly have a glance last 5 lines.
ନାଇଁ ଆମେ ସେ statement ଟା ବାହାର କରିବା 4 ନମ୍ବର ସାକ୍ଷୀ ନା କଣ
କୁନ୍ତି ପାତ୍ର
ଦେଖିବା ସେଟା କଣ କହିଛି ଠିକ କଥା
or he should have stated IO
again.
that I don't remember
No,
or
remember
without seeing
he has to see this
ସେ ତ
he has
yes,
to
go to the
he
statement
has
and
to-
answer
he
it.
has the right to go look into this
going through one
He has to go to the
not gone.
constituent and
question of I don't remember he is in his front that would be 161 would be there so he has every
after
right
going
to
to the
verify
one
and
section
answer it.
he will answer.
So Kunti Patra କହିଲା ମୋର ନାମ କୁନ୍ତି ପାତ୍ର ସୁଆଂଶ ମୋର ବୟସ 20 ହବ ଆଜି 7ଟା ବେଳେ ଆମ ସସରା ଗ୍ରାମରେ ସୁଆଂଶ ଇନ୍ସପେକ୍ଟର ପାଖକୁ ଯାଇ ବୟାନ ଦଉଛି ମୁଁ ମୋ ସ୍ୱାମୀଙ୍କ ସହିତ ମୋର ବାପ ଘରକୁ 1 ସପ୍ତାହ ହେଉଛି ଘାସ ବାଛିବା ପାଇଁ ଆସିଅଛି ଅଣ୍ଟି ସୁଆଂଶରେ ମୋର ବାପା ଶିବଛୁ ପାତ୍ରଙ୍କର ସୁଆଂଶ ଥିବାରୁ ଜମିରେ ଆମ ସାହିର ରେବତୀ ପାତ୍ର ମିନତି ସହିତ ଘାସ ବାଛୁଥିଲୁ ଦିନ ପ୍ରାୟ 1 ବାଜି ହବ ଆମ ପାତ୍ର ସାହିର ସୁଭଦ୍ରା ପାତ୍ର ନାଳ ସାଇଡରୁ ଆମ ଜମି ହିଡ଼ ଦେଇ ଛାଡା ଯାଇଥିଲେ ପ୍ରାୟ ଅଧଘଣ୍ଟା ପରେ ଅର୍ଥାତ୍ 1:30 ବେଳକୁ ଆମ ଜମି ତଳେ ନାଳ ପାଖରେ ମାରିଦେଲା ଆବାଜ ଶୁଣି ଠିଆ ହୋଇ ପଛପଟେ ନାଳ ସାଇଡକୁ ଦେଖିଲୁ ପ୍ରଫୁଲ୍ଲ ପାତ୍ର ତାର ସ୍ତ୍ରୀ ସୁଭଦ୍ରାକୁ ଚାକୁରେ ବୁଝି ଦେଇଛି ସୁଭଦ୍ରା ପାଣି ନାଳରେ ପଡିଗଲା ଆମେ 3 ଜଣ ହୋ ହଲ୍ଲା କରି ଘଟଣା ଜାଗାକୁ ଦୌଡ଼ିଲୁ ପ୍ରଫୁଲ୍ଲ ପାତ୍ର ଚାକୁ ହାତରେ ଧରି ଜଙ୍ଗଲ ଆଡକୁ ନାଳ ଡେଇଁ ଦୌଡ଼ି ପଳାଇ ଯାଉଛି ଆମେ ଏକଥା ଦେଖି ପାଟି କଲୁ ଲୋକଙ୍କୁ ଡାକିଲୁ ଆମ ଡାକିଲୁ ଆସ ପ୍ରଫୁଲ୍ଲ ପାତ୍ର ତାର ସ୍ତ୍ରୀକୁ ଚାକୁରେ ଭୁଷି ଦେଇ ଜଙ୍ଗଲ ଆଡେ ପଳାଇ ଯାଉଛି ଘଟଣାସ୍ଥଳରେ ପହଞ୍ଚି ଦେଖିଲୁ ସୁଭଦ୍ରା ଯିଏକି ମୋର ଭଉଣୀ ହବ ନାଳରେ ପଡି ଯାଇଛି ତାର ମୃତ୍ୟୁ ହେଇଯାଇଛି ଆମେ ପାଟି ଶୁଣି କେନାଲରେ ଗାଧଉଥିବା ଲୋକମାନେ ଦୌଡ଼ା ଦୌଡ଼ି ଆସିଲେ ସେତେବେଳେ ସୁଭଦ୍ରାର ମୃତ୍ୟୁ ହେଇଯାଇଥିଲା ଗାଁର ଲୋକ ପୋଲିସକୁ ଖବର ଦେଲା so this witness ଏଇ ଯୋଉଟା କହିଛି ନା he has not stated before me that the accused ran away from the spot being armed with knife it is clearly there ପ୍ରଫୁଲ୍ଲ ପାତ୍ର ଚାକୁ ଧରି କଣ ଜଙ୍ଗଲ ଆଡକୁ ନାଳ ଡେଇଁ ଦୌଡ଼ି ପଳାଇ ଯାଉଛି so this is there it should not have been this is some kind of it's a duty of the PP and the trial court ଏମାନେ କେହି ଠିକ ସେ କରିନାହାନ୍ତି ତାପରେ ଆଉ ଗୋଟେ ଯୋଉ କହିଲା as not stated before me the cry of the house ମରିଗଲା ବୁଆ they went to the spot ମରିଗଲା କହି କିନ୍ତୁ ସେମାନେ ଗଲେ ଜାଗାକୁ ନା
ସେଟା କହିଛି
see with it but context ହଉଛି ସେଇଆ ଯେ ଆମେ ଏଇଆ ପାଟି ଶୁଣିଲୁ ମାରିଦେଲା ଶୁଣି ଯାଇକି ଦେଖିଲୁ ସେଠି so this one is also there she has also not stated me that the deceased was lying in a pool but she has also not stated that they raised alarm there এটা ବି କହିଛି
ଆଜ୍ଞା
they raised alarm and thereafter how these things are going on କହୁଛି ଏଠି clearly ଯେ ଆମେ ପାଟି କଲୁ ଗାଁ ଲୋକମାନେ ଆସିଲେ
ଗାଁ ଲୋକ ଆସିଲେ
now IU has stated that he has not stated before me once the public prosecutor at the time of confrontation of the 161 statement, previous statement by the defense counsel, if he is very sincere and remains alert and see, then immediately he can object. Sir, এটা କହିଛନ୍ତି କାହିଁକି ଆପଣ ପଚାରୁଛନ୍ତି କୋର୍ଟର attention draw କରିବେ and if the attention is drawn the court's duty is to verify ତମେ ଏମିତି କହିନ in fact statement ଅଛି ନା
statement
तो
ଅଛି।
पब्लिक प्रोसिक्यूटर मध्ये अलर्ट रहइबो कोर्ट रो नोटिस को आनिबो आ पब्लिक प्रोसिक्यूटर चुपचाप बसी जीवो कोर्ट तार से टाइप मशीन भलिया काम चलेबो दैट इज व्हाई
फाइल भी पढ़िଥିଲେ ସିନା ଜାଣିବେ।
ଆଜ୍ଞା
that is why they
And
say
they-
that you are not
Main role is the public prosecutor to
हाँ
attentive at the time of the cross hearing.
ସିଏ କଣ କି ଗୋଟେ ମନେକର ଆଜି ଦି ତିନିଟା ସାକ୍ଷୀ କି ଅନ୍ୟ କେସ ରେ ଆସିଥାନ୍ତି ଚିଫ୍ କରେଇଦେଲେ ସେ ଭାବିଲେ ଆଗ ଡ୍ୟୁଟି
ସେ ବାହାରେ ଆଉ ପୁଣି
ସେ ବାହାରେ ଯାଇକି ଆଉ ଗୋଟେ ସାକ୍ଷୀକୁ ଟ୍ରେନିଂ ଦେବେ
right.
so they remain absent that is ordinarily
That
it
is
happens अच्छा कोर्ट तार से भावुଛ ये बोधे ठीक से डाकुଛନ୍ତି कोर्ट तार टाइप କରି ଚାଲିଗଲା प्रोब्लेम आराइज अच्छा ହେଲା ସେତେବେଳେ ବି ପାସ୍ କରି ଚାଲିଗଲା ଆଇଓ ଯେତେବେଳେ ହଉଛି ସେତେବେଳେ ଆଟଲିଷ୍ଟ
ସେଇଟା
ଅଲର୍ଟ
କରିବା।
ରୁହ ସିଏ ବି ନାହିଁ ସିଏ
ଆଇଓ ଅନ୍ତତଃ ନିଜେ ଭେରିଫାଇ କରିବା କଥା ସେ କଲା ବେଳକୁ ସେଟାକୁ ସିଏ
another practical problem is there, Miller. We are as a council, Miller, we are not being supplied with 161 statements also.
କୋଉଠି
ଆମକୁ in appeals, we are
ଆମେ
not
appeal
being supplied.
ଠିକ ଅଛି ନା
We have no access to 161 statements, so we have to rely on these, Miller. And
No,
this
no,
may also mislead your lordship.
ନାଇଁ ନାଇଁ no rightly you are right ଏଇ ଯୋଉ ଜିନିଷଟା ଆପଣ ଯଦି 161 ନାହିଁ ତେଣୁ ଆପଣ ଭାବୁଥିବେ ପ୍ରକୃତରେ ବୋଧେ ୱିଟନେସ୍ କହିନି
କହିନି
ଆଜ୍ଞା
ହେଲା କିନ୍ତୁ
ଆଜ୍ଞା।
ପ୍ରକୃତରେ କହିଛି
ଆଜ୍ଞା
ତେଣୁ ଆପଣ ଏଇ ଅନୁଯାୟୀ ମଧ୍ୟ ରିଟିନ ନୋଟ ପ୍ରିପେୟାର କରିଦେଇଥିବେ
ଆଜ୍ଞା
ତେଣୁ no, no, if
You fairly considered
no,
that
it's all right.
Yeah, he has gone through that, that's why he
Right.
told.
No,
Otherwise
that is good thing but it's not happening in one case we are verifying that the trial court who are very sincere the public prosecutor who are very thorough they used to remain alert and each time any such type of things happen they used to point it out no sir eta wrong pure confront କରୁଛନ୍ତି ଗୋଟେ statement ଅଛି ଆପଣ କହିବେ ଆପଣ police ପାଖରେ ଏ କଥା କହିନା ଇନଫ୍ୟାକ୍ଟ ଯଦି ଆଇଓ ବି ତାର ଆସିବ ସିଏ କହିଦବ ନା ଆଜ୍ଞା କହିନି ହଁ ତେଣୁ
actually ଆଗରୁ ହଉଥିଲା କଣ ମାନେ ଏଲି ଆମ ଏଲି ଇଏରେ ବି ଯେତେ ଆପଣଙ୍କର ଆଇଓ ହଉ କି ଏନି ୱିଟନେସ୍ they went to the house of the PP yesterday night
they read the entire case diary
enter then
case diary
prepared
ପୁରା
then
କାରଣ
answer
ସିଏ
nowadays they're directly reaching the court
ସିଏ ଆଗରୁ ମାନେ ତାଙ୍କର କେସ୍ ଡାଏରୀ 2 ବର୍ଷ ହୁଏତ 2 ବର୍ଷ 3 ବର୍ଷ ପାସ୍ କରି ଯାଇଥିବ ନା
ଆଜ୍ଞା
ତେଣୁ they used to thoroughly go through the case diary
exactly
evidence ମଧ୍ୟ ଦେଖନ୍ତି evidence ଦେଖିକିନି then
ଘରେ
they
ଆସିକି
used to
ଟ୍ରେନିଂ ହୁଏ ତାପରେ
ହଁ
ରାତିରେ ତାପରେ ଯାଇକି ତାପରେ ଏବେ ତାକୁ
ହଁ
ଡାଇରେକ୍ଟଲି ଆଇଓ ଆସି ପହଞ୍ଚୁଛନ୍ତି ସେଇଠି ଅନ୍ ଦି ସ୍ପଟ
ତେଣୁ ଚଢିଗଲେ କିଛି ନାହିଁ ସେମାନେ ଡିପୋଜିସନ ଯୋଉଡାକ ଅଛି ଦେଖିକି କହିଦେବେ ବଟ୍ ଏଇ ଯୋଉ ପର୍ଟିକୁଲାର ଜିନିଷ ଗୁଡାକ ଏଠିଆ ପାଇଁ ଏକ୍ସଟ୍ରିମଲି କେୟାରଫୁଲ ହବା କଥା ମାନେ ଗୋଟେ
ମର୍ଡର
eyewitness ର
କେସ୍
statement
In some cases of recent times, your lordship will find IO was examined as the mid witness. ତା ପଛରେ ବି witness examine ହଉଛନ୍ତି. In some cases, this
ଏଇ
is
ୱିଟନେସ୍ ଟାର ଆପଣ ଯଦି ଚିଫ୍ ଟା ଦେଖିବେ ଆଉ 161 ଭେରିଫାଏ ନ କରିବେ ତାହେଲେ ଚିଫ୍ ରେ ସିଏ କଣ କହିଲା ଆମେ ପାର୍ଟି ଶୁଣିକିନି ଗଲୁ ମରିଗଲି ଆମେ ଯାଇକି ଦେଖିଲୁ ଏବଂ ଦେଖିଲୁ ଯେ ଡିସିଜ ଗୋଟେ ରକ୍ତ ଇଏରେ ପଡିଛି ଏବଂ ତାକୁ ଦେଖିକିନି ଆମେ ଅନ୍ୟମାନଙ୍କୁ ଡାକିଲୁ ଏବଂ ଦେଖିଲୁ ଯେ ମଧ୍ୟ ଇଏ ଦୌଡ଼ିକିନି ପଳେଇ ଯାଉଛି ଏତିକି ତ ସିଏ କହିଛି
ଆମେ
entire thing goes in the if we
ଯଦି ସଜେସନ ରେ ଗଲେ
ସଜେସନ ରେ ପଳେଇଲା
ପଳେଇଲା
ସବୁ
ସବୁ।
ମାନେ 161 କନଫ୍ରଣ୍ଟ ହେଲା ଆଇଓ କହିଦେଲା ଯେ ନାଇଁ ସେଟା କିଛି କହିନି but in fact that is there
it is there.
so then let us come to the next witness the other
Five
eyewitness you said
Five.
PW5
Page 54.
yeah
I know the informant of this case. I know the accused standing in the dock. I also know the deceased Subhadra, who was the wife of the accused. The occurrence took place more than 6 years back near Malar Basanala at village Sarsara at about 1 to 2 p.m. At that time, I, along with PW4 and Minati Patra, was weeding out the grasses from the land of Srivatsha Patra. Hearing the cry of the deceased, such as Morigala, Morigali, we three rushed to the spot and found the deceased was lying dead. She was bleeding injury. She had bleeding injury on her belly, and at that time found the accused running away towards the jungle holding a knife.
consistent with the same
same
There was profuse bleeding injury on her belly. Then we raised Hulla, and hearing our Halla, villagers came to the spot and we narrated the incident to the villagers.
Forward to the P4.
So exact same ଜିନିଷ ଆଜ୍ଞା. After raising halla by these two witnesses, others came in. Cross examination. My father has got about 3 acres of landed property. My family depends on cultivation. I also used to work as a daily laborer. Daily work in labor.
In the field of Tapor line.
As a laborer.
For the first time, we had gone to work in the field of Srivatsha. There also, their lands belong to.
ମାନେ ସିଏ କହୁନାହାନ୍ତି ଯେ ଆମେ ଲେବର କାମ ପ୍ରଥମ ଥର କରୁଛୁ ବୋଲି।
ଆଜ୍ଞା।
ଲେବର କାମ ଆମେ କରୁ
ତାଙ୍କ ବାରିକୁ
କିନ୍ତୁ
ଯାଇଛି
ଶ୍ରୀବତ୍ସ ଜମିକୁ ପ୍ରଥମ ଥର ପାଇଁ ଯାଇଛି। ତା ମାନେ ହଉଛି ସେଇଆ। Yes.
I cannot say at what time Subhadra had come to the spot. I cannot say it in any of companion who had accompanied the deceased. The nearby villagers used to got that nala for bathing.
Go to that nala.
Again, I'm obliged to go to that nala for bathing and easing purpose. It is not a fact that when we went to the spot, people were taking bath in the nala. There is a water channel in the upper side of the land where we were working. I cannot say whether people were taking bath at that time in the said water canal. It is not a fact that I have not stated to the IO that hearing halla, the person who were taking bath in that canal rushed to the spot and found the deceased lying dead. I have not seen the assault on the deceased. I have not seen who killed the deceased, but I found accused Profula running away from the spot. The width of the nala is about 50 feet. The distance between the place where we were working and the dead body was lying about 100 cubits. We were weeding out the grass from the land having bent down. This was rainy season. The weeding operation work was going on in the fields. It is not a fact that other people were engaged in their respective lands. It is not a fact that I have not stated to the IO that hearing the cry of the deceased Marigali, we rushed to the spot. But in fact, she has stated. Usually our villagers came to that nala for taking bath. Throughout the day, people used to come to that nala. None has come to the spot except we three from the bathing hut of the nala. The bathing hut of the nala is at a distance of 50 cubits from the spot where the dead body was lying. The water channel is at a distance of 100 cubits from where the dead body was lying. We have not personally reported the matter at the village to anybody. First PW2 arrived at the spot, followed by other villagers. They came to the spot from the village Sahi. Your Lordship will mark this line. The jungle was at a distance 100 to 150 feet where we are engaged in weeding work. The jungle as well as the nala situates in the north side of the paddy field where we were doing weeding operation. The level of the canal is situated below 150 feet from the level of the paddy field. It is not a fact that the Bodo Jora Nala adjacent to the paddy field. The adjacent land to the Nala belongs to Srivatsha Patra. The place where the dead body of the Subhadra was lying is not visible to the place where we were working. Profula had already crossed the Nala while we arrived at the spot. Accused Profula had worn a lungi. I cannot say the color of the lungi. Accused Profula was armed with a pen knife, approximately length about 5 inches to 6 inches. The knives are available in the market. I noticed 2 injuries on the right side. The jungle is adjacent to the Bodojoro Nala. The jungle situates on the river side of the paddy field. The deceased Subhadra is my sister by village courtesy. It is not a fact that I had enmity with the accused Profula prior to the occurrence. It is not a fact that I have not seen the occurrence and I am deposing falsehood. It is not a fact that I have not seen the accused running away from the spot holding a knife. This is Miller PW4.
No contradiction in the evidence of this.
No, Miller. As it is, PW5 and PW4 are replica.
କାରଣ ସେଇ ଯୋଉ ମେନ୍ ନାଳଟା ଯୋଉଟା ଯାଇଛି ସେ ତଳେ ଯାଇଛି ଏଇଟା ଗୋଟେ ତାକୁ କନେକ୍ଟିଂ ବୋଧେ ପାଣି ପାଇଁ ସେ ଗୋଟା କରିଛନ୍ତି କନେକ୍ଟେଡ ଡିସିଜ୍ ସେଇଠି ପଡିଥିଲା ମେନ୍ ନାଳଠୁ
ଆଗରୁ
ଆଗରୁ
ତା ଆଗରୁ ବି ଆଉ ଗୋଟେ ଲ୍ୟାଣ୍ଡ ବି ଥିବ ସେଠି
ଆୟୁ କହୁଛି
କିନ୍ତୁ ମେନ୍ ନାଳଟା ଯାଇଛି ଯୋଉ ତଳେ ଏମିତି
ବଡ ଲମ୍ବା ହେଇଛି
ସେଇଟା ହଉଛି ଯୋଉଟାକୁ ସେମାନେ
ସି
କହୁଛନ୍ତି
ବଛ
ତାହେଲେ-
ତଳକୁ ଯୋଉ ଦିପଟେ ନାଳ ଜଙ୍ଗଲ ରହିଲା ଏପଟେ ରହିଲା ସେ ମଝିରେ ବି ଲାଇନ ଥିବ ଯୋଉଟା କି
ହଁ
ଅଲଗା କାହାର ଯୋଉଟା ପଚାରୁଛନ୍ତି ସେମାନେ କହିପାରୁନାହାନ୍ତି କାହାର।
Now, who reached the spot, my lord? Another witness reached the spot. That is PW2 and PW30.
There is slight difference in the statement of the witness during cross-examination.
ହେଲା
That is at page 55.
Yes.
Page 55,
Okay.
cross-examination para 2.
Okay.
I cannot say, the sentence has started, I cannot say whether people were taking bath at the time
exactly
in the said water channel.
It
It is not a fact that I have stated to the IO that hearing our hulla, the persons who were taking bath in that channel rushed to the spot and found the deceased lying dead. But
this has
there
been
is a
stated.
difference.
Again, this has been stated.
PW4 has stated so.
So how do you get over this witness who have two witnesses who have stated to have reached the spot hearing that holla, and the deceased was lying there with bleeding injuries on the vital part of the body like belly, and the appellant was running away holding that knife.
I am questioning their presence itself, my lord.
Kar,
These two witnesses.
how you?
I am your lordship may kindly come to that Gramaraki who has accompanied the my lord, informant.
PW13
PW13 who reached to the spot at 1:30, my lord. And who has accompanied the
PW2
Yes, PW13.
PW13, page 77. I know the, your lordship.
Yes.
I know the informant of this case. I know the accused standing in the dock. I know the deceased Subhadra Patra, who was the wife of the accused. The occurrence took place at 29/8/98 at 1:30.
Just a minute. You would a grammar okay.
Again. And also accompanied PW2 to lodge the FIR.
And in the FIR, the names of these two ladies found place.
Also Basan, PW13.
Okay.
Yeah, na bhi achhe FIR.
Padhantu.
The occurrence took place on 29/8/98 at 1:30 p.m. in the Malarbasa Nala at village Sarsara. I am working as village Chowkidar. The accused caused the death of the deceased by stabbing knife on her abdomen. After hearing the incident, I, along with other co-villagers, went to the spot and saw the dead body of the deceased lying there. I also noticed bleeding injuries on her left side abdomen. I, along with the informant, went to the PS to report the incident. PW2 orally reported the incident before the Thana Babu, which was reduced in writing by the latter. Exhibit 2 already marked as the said FIR. And Exhibit 2/3 is my signature thereon. Exhibit 2 is marked with the objection. On 30/8/98, the IO seized the bearing apparels of the deceased along with the common certificate on production by escorting constables in my presence and prepared the seizure list, which is now marked at Exhibit 10. Exhibit 10(1) is my signature thereon. Cross-examination partner. I was examined by the IO on 29/8/98. I have not examined thereafter by the IO. I have no direct knowledge about the occurrence. I cannot say the date of my birth. I had joined Chowkidar on 26/7/97. I cannot say the exact date when my father expired. I cannot say the exact date when the marriage solemnized between the accused and the deceased. For the first time, I heard about the incident from Chokkadola Naik, who is my co-villager. I proceeded to the spot at 1:30 p.m. PW2 and the father of the deceased, since dead, arrived on the spot after my arrival. At the time of my arrival, 20 to 30 male persons were already present on the spot. Some people were also weeding grass near the spot. The cultivable land situates in the southern direction of the spot. It is not a fact that the cultivable land situates in higher level than the nala. Nala, the land, and the dead body was lying on the same level. For the first time in my life, I had been to the spot on that day. The Thana Babu used to take my signature whenever I got to police station, accompanied by the agreed parties. I had already deposed twice in the court as co-signatory in the affair before this court. I always put the date when I put my signatures. I have not mentioned the date in Exhibit 2 and Exhibit 10. My village is at a distance of 5 kilometers from the PS. I have got one bicycle. Immediately after the incident, Your Lordship may mark these 3 sentences. I have not gone to the PS. Before going to the PS, myself, Tikkeswar, Natho, and other villagers sat together and discussed about the course of action. According to the decision, the affair was lost. We went to the PS and reported the incident. At that time, OIC of the PS was not present at the PS. Therefore, message was sent to Bonai police. After sunset about 6 p.m., the IO of Bonai came to the spot. We reported the incident to Jamadar, who was in charge of the PS in absence of the OIC, who reduced the same into writing. I have not reported anything to the circle inspector. We returned to the village by our bicycle, and the circle inspector came to the spot thereafter. The IO conducted inquest over the dead body and dispatched the dead body for PM postmortem examination on the same night. I had accompanied by the dead body. When the IO seized the command certificate of the Constable Balaram Bhoi, I was not issued with any command certificate. It is not a fact that I have not accompanied by the dead body and that nothing was in my presence, nor I have stated before the same. I have stated about the same before the IO. It is not a fact that I am deposing falsehood in connivance with the relations with the deceased. On being directed by Thana Babu, I put my signature on Exhibit 2. In fact, my lord, he has stated that 20 male persons were present at the spot while he arrived. And after his arrival, PW2 came, who has lost the affair, and the my lord, father of the deceased. And in fact, your lordship may kindly come to PW2, my lord, who also reached the spot. Page 41.
So this PW2 has also stated that he, along with PW13, went to the police station and orally reported the matter. So, in what way is there anything discrepancies between the two witnesses?
Your lordship,
Because
nowhere it has been explained, my lord, how this Natha, who has reported to this informant regarding the incident, came to know. Everybody says that he is the first person to reach there.
PW13.
PW2, my lord. There, both the eyewitness says that he is the first person to reach there. But how could he came to know through Natha?
Well,
Natha is the father of the deceased.
Because Natha has not been examined. And so far,
there is no
seeing
answer.
the spot after the occurrence, how it will overcome the witness of the.
That is the main crux of the
main
matter.
crux of the-
किए आगे रहला किए पछे
Pachhe gala, it doesn't matter.
20 लोक पहुंचिले किए को आसिबो घटना पार्टी होजी स्प्रेड हे जाइथिबो ये डेड बॉडी पड़छि
किए गार्ड शुणिकी आसी पहुंचले
किए कोन मार्क करथिबो ये आसिला कागज रे टिपी रखथिबो ना कोन तेणु मेन होजी भाइटल फैक्टर होछि जे आई विटनेस
how
मान
to overcome the pitfalls 4 and 5 and also the pivotal 6, the leading to discovery of the
your
weapon.
lordship, that fact cannot be ignored, that there has been considerable deliberation, discussion, meeting for before lodgement of the affair.
ଯେତେବେଳେ ଘଟଣାଟା ହେଲା ସେଇ ଯୋଉ ଲାଇନଟା ଆପଣ ପଏଣ୍ଟ ଆଉଟ କରୁଛନ୍ତି ଯଦି ଯେ ଆମେ କଣ କରିବା ଏଥିପାଇଁ ନା ନାଇଁ ଥାନାକୁ ଦେଇଦବାଟା ଭଲ ତ ଏଇଟାରେ ଡେଲିଭରେସନ କଣ ହେଲା
You cannot take in the other way that there is a plan for implement the
ଗୋଟେ କିଛି ନଥାନ୍ତା delayed would have been caused to implicate somebody falsely, that matter would have been a different
way.
ତେଣୁ ଏମାନେ just ବସି ଏବଂ you see the time ମାନେ ଆପଣଙ୍କର ଘଟଣାଟା ହଉଛି as per the FIR it 1:30 ବା 1 ରୁ 1:30 ଭିତରେ ଏବଂ ଯୋଉ ପ୍ଲେସ୍ ଅଫ୍ ଅକରେନ୍ସ ରୁ ଡିଷ୍ଟାନ୍ସ ଟା ଦେଖଉଛି 16 କିଲୋମିଟର ମାନେ ଆପଣଙ୍କର ପେଜ 28 रे distance from the police station
Police
place
station
of
spot.
occurrence होची it is 16 kilometers. ताकू जाइकिनी सेमान कवर अप करिकिनी 4टा बेले आपनकर
FIR लिखले
FIR प्रेजेंट हेची इन्फॉर्मेशन रिसीव्ड होची 4टा बेले तेणु आधिरे कोठी आपनकर माने ये मिलिला जे ताकू मैनिपुलेट करिवार बा सेमती तो किछि
What I suggest, my lord,
एविडेंस नाही.
my lord, pleading is that this is to be seen along with that absence of rigor mortis. That is what I am. This is to be seen along with the fact that rigor mortis was absent from the body. My contention is that this is all to be read with that, my lord.
Rigor mortis ro pra
and you have not also come in the cross examination. Any question is put to the doctor on
It is
that.
in fact your duty to ask
no
questions.
rigor mortis ro आपण ए जो we are also seeing that ए जो how in rainy season, how in summer season,
season.
how in winter season there would be time gap. ତେଣୁ ଏଠି
36 is the list.
ଏଇଟା ଏଇ ଦେଖନ୍ତୁ rigor mortis can set in faster hala in
Okay.
warm weather compared to cooler temperature hala तो जदि cool temperature अछि then एटा टिके delayed हबो warm temperature अछि तो fast हबो. Rigor mortis is a post-mortem process that occurs due to stiffening of the muscles in the body. This process typically starts within few hours after death and can last up to 72 hours, depending upon various factors. One of the factors that can affect the onset and progress of the rigor mortis is the temperature of the surrounding environment. In warmer temperature, the body's metabolic process continue for a longer period after death, which can result the faster onset of rigor mortis. In cooler temperatures, the onset of rigor mortis may be delayed and the process may progress more slowly. It is worth noting that while the temperature can influence the onset and progress of rigor mortis, other factors such as individuals' age, health, cause of death can also play another role. Additionally, other postmortem changes such as liver mortis, the setting of the blood in the body's lower parts, algor mortis, the cooling of the body after the death, can also provide information about the timing of circumstance. सी आपनकर जो डॉक्टर केते मेकानिकली कहिछि माने से जो बही के जेमति पढ़ी दियंतिनी से कहूछि आज्ञा 36 घंटा ए जो कोन 30 घंटा पास कर जाइतला तेणु ए that is the only reason
किछि अलगा रीजन भी देना.
he has not assessed the in what how the dead body was found, what is the weather condition, सेगुडाक से किछि कहनी खाली तारो the reason which he has given that
36
36
have passed out.
is
Only that.
more than 36 hours as rigor mortis has passed up. So rigor mortis टा appear करिवो केतेबेले आ pass up करिवो केतेबेले या पई विभिन्न जिंस को assess करिया पड़िवो सेइतपई जोटा right from the beginning we are telling that it would straight jacket formula नै गोटे जे आपनकर गोटे आइस जगारे कूलर जगारे से हिल स्टेशन जोटा हम एग्जांपल दोथु सेठी जा हबो एठी ओडिसा रे भी सेम time gap हो. It is not that uniform. It depends upon several factors. So that they कहउछन age मध्ये one of the factor, health condition गोटे factor, हाला cause of death is also another factor. So many things. Who type ro.
But my contention is all these aspects which your lordship is pointing out, that was never, my lord, asked by the prosecution nor by the court itself. That is what honorable apex court has said.
It's all right, but we cannot. Why it is said that the witness, the court is expert of the expert. When you are telling one thing, the reasons which you be given, that must be a justifiable ground. ଆପଣଙ୍କର reason जोटा ଦେଇଛନ୍ତି, that is in medical science it is not acceptable. ତେଣୁ ଆପଣଙ୍କର କୋର୍ଟ ସେଇଥିପାଇଁ ଆପଣ ଯୋଉ reason ଟା ଦେଇଛନ୍ତି ଗୋଟେ ଇଏଟା ଆସିବ ମନେକର ଗୋଟେ ହ୍ୟାଣ୍ଡ ରାଇଟିଂ ଏକ୍ସପର୍ଟ ଆସିବ ଆଜ୍ଞା ମୁଁ ଇଏ ୱିଟନେସ୍ ଆକୁ ମୁଁ ତାକୁ କମ୍ପେୟାର କଲି ଆଉ ଇଏ ତା ସାଙ୍ଗରେ ମୁଁ ଆଦେହରୁ ଓପିନିଅନ ଯେ ଏଇ ଚିଠି ଏଇଟା ଯିଏ ଲେଖିଛି ସେଇଟା ହଉଛି ତା ହ୍ୟାଣ୍ଡ ରାଇଟିଂ ଖାଲି ଏତିକି କହିଦବ whether the court is bound to accept it no you must give reason ଯେ ତାର ଏଇ ଟାଇପ ର ରହିଛି ତାର ଲେଖାର ଅକ୍ଷର ଏଇଗୁଡାକ ସେ ଏତିକି ଏଇଗୁଡାକ reasons ଦେଲେ then that is why it is always said that unless uh, the expert's evidence is backed by reasons and that reasons are acceptable, the court is not there to accept every expert evidence is because it is an expert evidence. ହେଲା ତେଣୁ ଏଠି ଯୋଉ reasons ଟା ଆପଣ ଦେଇଛନ୍ତି ଆପଣ we have already seen that Google ରେ ଏମିତି କିଛି straight jacket ତାର ଗୋଟିଏ reason ଯେ 30 ଘଣ୍ଟା ମାନେ death ଟା 36 ଘଣ୍ଟା ପୂର୍ବରୁ ହେଇଥିଲା କାହିଁକି ନା rigor mortis ଟା ପାସ୍ କରି ଯାଇଥିଲା that is the reason କାରଣ rigor mortis ଟା set ହୁଏ ଗୋଟେ ordinarily 2 ଘଣ୍ଟା ଆଗରୁ ଷ୍ଟାର୍ଟ ହବ ହେଲା 2 ଘଣ୍ଟାରୁ ଷ୍ଟାର୍ଟ ହବ ଏଇଟା 12 ଘଣ୍ଟା ଲାଗିବ 12 ଘଣ୍ଟା ପରେ ପୁଣି ଆଉ 12 ଘଣ୍ଟା ରହିବ ଦେନ୍ ଇଟ୍ ପାସ୍ ଅଫ୍ କରି ଯାଇଥିବ ସେ କାଲକୁଲେସନ କରିଦେଇକି ପକେଇ ଦେଇ ଚାଲିଗଲା ଯେ ଏଇଟା 36 ଘଣ୍ଟା କିନ୍ତୁ ମେଡିକାଲ ସାଇନ୍ସ କହୁଛି ଆହୁରି ବହୁତ ଜିନିଷ ଫ୍ୟାକ୍ଟର ଅଛି ଏଠି ଆମେ ମଧ୍ୟ ଦେଖି ସାରିଲୁଣି ଯେ ଡେଡ ବଡିଟା ଇଏରେ ପଡିକିନି ରହିଛି କୋଉଠି ନା ନାଳ ଭିତରେ ସେତେବେଳେ ବର୍ଷା ଦିନ ଥିଲା ଏବଂ ପୋଷ୍ଟ ମାନେ ଇଏ ଆସିବା ପର୍ଯ୍ୟନ୍ତ ସେଇଠି ପଡିକିନି ରହିଛି ଥଣ୍ଡାରେ ରହିଛି ୱେଦର ହଉଛି ରେନି ଡେ 7 ଦିନ ହେଲାଣି ରେନି ଡେ ମାନେ ବର୍ଷା ଇଏ ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ
that means in cold weather what your lordship is
cold weather
cold weather ରେ ସେଟା ଅଧିକା time ନବ it will take another 48 hours
କଣଟା
recession time will take 48 hours passing of rigor mortis that is what I am Milord pointing out if Milord in a cooler stage Milord passing of rigor mortis is slow
no
what your lordship is saying
ଆରମ୍ଭ ହବ ଡେରି ହବ
ଆଜ୍ଞା
rigor mortis can set in faster in warm weather ହେଲା compared to cooler temperature ତେଣୁ cooler ରେ କଣ ହବ ନା ଏଇଟା ଟିକେ ଡେରି ହବ ଆରମ୍ଭ ହବାଟା so ଡେରି ହବ ଯଦି ଆରମ୍ଭ ହବା ତେଣୁ କଣ କରିବ ନା obviously ପାସନ କରିବାକୁ ମଧ୍ୟ ଇଏ ରହିବ ତେଣୁ ଡେରି ହବ ସେଇ ଅନୁଯାୟୀ ତେଣୁ
ଏଠି ଆଜ୍ଞା explain ହେଇପାରୁନି ତାହେଲେ that is what I am my contention is
ଆପଣ ଏଇ ଯୋଉ whole ଜିନିଷ ହଉଛି ଏଇଟା that is one of the reasons
yeah but I
one of the reasons that is not and apart from that age factor କୋଉ ଟାଇପ ର ଡେଥ ହେଇଥିଲା ଆପଣ ଗୋଟେ ବର୍ନ ଇଞ୍ଜୁରୀ କେସ ରେ ଆଉ ଗୋଟେ ଷ୍ଟାବିଂ ଇଞ୍ଜୁରୀ ଏଇ ଆକୁ ଆପଣ କମ୍ପେୟାର କରିପାରିବେନି ଯେ ତା ଦେହରେ ଯାହା ରିଗର ମର୍ଟିସ ଆସିବ ଆ ଦେହରେ ଆସିବ ତେଣୁ ଭେରିୟସ୍ ଫ୍ୟାକ୍ଟର ଏଜ ମଧ୍ୟ ଆଉ ଗୋଟେ ଫ୍ୟାକ୍ଟର
but my problem is there Milord there is PW4 and PW5 that is there is evidence of PW4 and PW5 that is why my this point will not Milord seems to be catching
this unless the eyewitness account is dislodged merely because ସେଇଟାକୁ ଆପଣ ଆଉ ଏଥିରେ ମଧ୍ୟ ଗୋଟେ ମୋଟିଭ ଟୁ ସମ କାଇଣ୍ଡ ଅଫ ମୋଟିଭ ରହୁଛି କଣ ଯେ ଯୋଉ କମ୍ପ୍ଲେନ ଟା ହେଇଛି ଯୋଉଟା କମ୍ପ୍ଲେନ ରେ ଯାହା ହେଇଛି ବାଡିଆ ପିଟା କରିଥିଲା ଇଏ ଗୋଟେ ରିପୋର୍ଟଟେ ମଧ୍ୟ ଦେଇଛି ଯୋଉଟା କି PW3 କୁ ଛାଡି ଦିଅ ବଟ୍ PW9 କହୁଛି ମଧ୍ୟ ଯାହାକୁ ସେ ରିପୋର୍ଟଟା ପ୍ରେଜେଣ୍ଟ କରିଥିଲା ସେ ରିପୋର୍ଟଟା ମଧ୍ୟ ପ୍ରମାଣିତ ହେଇଛି ଏବଂ 4/3 ହିସାବରେ ମାର୍କ ହେଇଛି ଯୋଉଥିରେ ଲେଖା ହେଇଛି ଯେ କଣ ତାକୁ ହେଇଛି ଏଗୁଡାକ ଗୋଟେ ସରକମଷ୍ଟାନ୍ସ ଯେ that may be one of the reasons ଯେ ତୁ କାହିଁ ଏଇଟା ଯାଇକିନି କାହିଁକିନି କହିଲା କମ୍ପ୍ଲେନ କଲା so after getting that complaint from PCC, we didn't talk the he has not ତାକୁ କିଛି କହିନଥିଲା ସେ ବିଷୟରେ ମାନେ କହିଲେ 2 ଦିନ ପରେ ବୁଝିବ ମାନେ ଯୋଉ ଯଦି କଲା ସେଇଟା ଆକ୍ୟୁରେଟ ନଲେଜରେ ଥିଲା ବୋଲି that no such a that it is otherwise he has stated that after receiving that complaint from this PW3 PW13 has stated that about the incident from PW13 PW9 Yes, many things. No, he has stated that, but after this, it might have come from to the knowledge of that person. ये निजी हुए तो जाएंगे नहीं कोई तो वो डिसीज जाए मुझसे बाड़े के मुझे कंप्लेन दी है तो possibility is there because जो लोकटा କହିଥିବ ହୁଏତ ତାଠୁ source ରୁ ପାଇଥିବ ସିଏ ତ ମରିଗଲା ତେଣୁ ଆଉ ଏଠି ଘର ଚାରିକାନ୍ଥ ଭିତରେ କଥାଟା ହେଲା ଅନ୍ୟ କିଏ ଜାଣିବ ସେଠି ଏ ବିଷୟରେ. But fact that one complaint has been given relating to the assault by the appellant to the deceased.
And also that P12, my lord, the mother of the deceased, also corroborated to the statement of the P9 and the 3
regarding that
regarding the
complaint.
assault and the complaint lodged by the deceased.
पढ़िले PW12 का देखिए.
PW12 is at page 74, my lord.
She is the mother of the deceased.
This mother of the deceased. Page 74.
हाँ, ठीक पढ़ो.
I know the informant of this case.
Because she is the best witness to say how the daughter was treated by the appellant.
Again.
କାରଣ ମା ମାନଙ୍କୁ ଝିଅ ମାନେ ଅର୍ଡିନାରିଲି କହୁଥିବେ ତ ଏଇ ସବୁ ଜିନିଷ. Yes.
Page 70. Lordship, I know the informant of this case. I know the accused standing in the dock who is my son-in-law. The deceased Subhadra was my daughter and the wife of the accused. The occurrence took place 6 years back near Malabasala Nala at village Sarsara at about 2 to 2:30 p.m. on Saturday. The accused used to assault my daughter during her lifetime. On Wednesday, prior to the alleged occurrence day, the accused assaulted my deceased daughter by means of a stick. And as the same was unbearable, she came to my house and showed me the assault part on her body. Thereafter, she reported the incident to the village committee. At that time, Lingaraja was the president of the village committee.
Lingaraj is that PW.
Your lordship has already.
PW9 na kete.
Lingaraj was PW3.
He was actually secretary.
She is PW3. Of the village committee, and Orokhita was the secretary. এটা উল্টা কহি ଦେଇଛି.
ଆଜ୍ଞା. ଗୋଟେ ହଉଛି PW3 ଆଉ ଗୋଟେ ହଉଛି
PW9. My deceased daughter reported them in writing about the alleged torture on her by the accused frequently. The village committee had decided to sit over the matter on the next Monday. But on the alleged date of occurrence, while the deceased daughter had gone to the spot to attend call of nature, the accused dealt a knife blow on her right side abdomen, causing her instantaneous death. At that time, I had gone outside to weed out the grasses and getting information about the incident. I rushed to the spot and found that the deceased was lying dead. I also noticed bleeding injury on her abdomen. The accused fled away from the spot after committing murder of my deceased daughter towards Jagyajhudi Hill. I have no cross-examination. I have no direct knowledge about the incident. On that day, I was engaged by one Bhut Patra of my village to do the wedding operation work. I returned home in the afternoon after completion of work, and at that time the sun was about to set. Gauri Patra informed me about death of the deceased. Gauri Patra is alive and she is available in the village. Then I reached to the spot and found the Subhadra was lying inside the Nala. Many village people were gathered at the spot. After the incident, I have not visited to the house of Prafullo. I have not talked with PW4 and PW5 on that day. I have also not talked with PW4 and PW5 about the incident till today. I noticed
ecchymosis on the person of my daughter on Wednesday when I came
on Wednesday when she came to my house being assaulted by the accused. I also noticed external injury on her thigh, on the forearms. I have not reported the matter to PS regarding the assault by the accused on that day. Accused Prafullo had married my deceased daughter as per our caste custom and rites. I cannot say the name of the priest who solemnized the marriage. One Tara Patra was performing as barber in the said marriage. A pond situates near our village. Our village people used to go to that pond for taking bath, including her family members. and also do other day-to-day work such as washing utensils, clothes, etc., and used to attend the call of nature. The pond situates close to our house, and the Nala is at 2 kilometers away from our house. My house is adjacent to the house of the accused. This is not a fact that the quarrel between my accused and the deceased was not taking place frequently. It is a fact that I have not stated before IO that on Wednesday prior to the alleged occurrence, the accused assaulted my deceased daughter by means of a stick. And as the same was unbearable, she came to my house and showed me the affected parts of her body. Subhadra does not know reading and writing. The report submitted by the deceased daughter before the village committee was cried by Lingaraj Patra. Again says one Gonda boy had written the same. It is not a fact that Lingaraj is the son of Kampa. This part is important, paragraph 7. The deceased was attending the call of nature and taking her bath in the village pond. It is not a fact that I am deposing falsehood. It is not a fact that the accused and the husband of the deceased.
So, she is a post-occurrence witness, but the evidence of this witness is relevant because
regarding that quarrel part.
Right. And she had also seen about the injuries caused on the body parts of the deceased.
Again.
These are the relevant thing is that because he was, and subsequently she came to that spot where the dead body was found and saw that body.
And let us come to the Schedule 6 matter.
PWC is that discovery part.
That knife was recovered at the instance of the appellant, right?
Again. That is at page 58. Lordship got it? Page 58.
Yes, yes.
I know the informant of this case. I know the accused standing in the dock. I also know the deceased Subhadra, who is wife of the accused. The occurrence took place more than 6 years back. 7 to 8 days after the alleged incident, police called me to Jagya Hudi Pahad hill of our village. I accompanied the police to the said jungle and other villagers also accompanied us. The police arrested the accused Prafullo from the said jungle. While he was under arrest by the police at the time of interrogation, the accused confessed his guilt to have caused murder of the deceased near Bodojora Nala and also declared that he has concealed the knife in the said Pahada. Thereafter, police recorded his confessional statement. The contents of the said confessional statement was read over and explained to us by the police. Thereof, the accused and myself put our signature. Exhibit 5 is the said confessional statement and Exhibit 5/1 is my signature. The accused also further disclosed that he would give recovery of the said knife, saying as the accused had led me along with police and others to the forest and gave recovery of the knife which was kept on a stone. Then police seized the said knife and prepared the seizure list in my presence. This is the said seizure list which is marked as Exhibit 6 and Exhibit 6/1 is my signature thereon. I can identify the said knife if it is shown to me which the accused gave recovery. On being shown to the eyewitness, he correctly identified the knife which is now marked as MO1 which bears his signature on a paper slip.
Yes.
Cross-examination. I cannot say the date on which the seizure was made. The IO seized the knife at about 1 p.m. Police came to our village at 12 noon. Nityananda, Dhananjaya, Sudam also accompanied with us. Bhagyagan Hudi Pahad is situated in the north side of the Bodojura Nala. Our villagers used to go to that village for collecting firewood. The people used to sell the firewood after collecting the same from the said hill. The hill is accessible to others. At that time, when we arrived in the jungle, other people were engaged in cutting the firewood. The knife was lying in an open rock. This knife, like MO1, is commonly available in outside. It is commonly used as household. The MO1 having special identification mark as the same is slightly bent on its upper pointed end and its handle having thread. Generally, thread is made in the handle portion of the knife to put the same in wooden handle. If the knife is used roughly on the upper pointed end of the MO1, will be bent.
Will be bent.
The unused knife like MO1 is also commonly available in the village. I cannot say how many signatures were obtained by the IO from me. I gave one signature at the place where the accused gave recovery of MO1, one signature at village Sarsara, and one signature at hospital at Sarsara. The police arrested the accused at about 1 p.m. It is not a fact that by then the MO1 was seized. It is not a fact that before the accused gave the recovery of the MO1, it had come to the notice of the others. The rock was surrounded by the trees. The other rock was lying near the rock in question. I cannot say how many big trees were there around the rock. It is variety and its variety. It is not a fact that the accused has not confessed his guilt, has not led us to the place that gave recovery of the MO1 in my presence. It is not a fact that I have not deposed falsehood in the instance of the police.
So this witness coupled with the IO's evidence
Regarding discovery
regarding that MO1, that knife was recovered from that hill where it was kept, and accordingly it was also sent for the chemical examination.
page
C report re kon asila?
He reported
page
not
88.
9, right?
No blood.
Page 90.
Acha, no blood asila.
Because he was arrested on 5/9. After 5 to 6 days now.
No,
And
possibility of କାରଣ openly
ରହିଥିଲା ନା
openly ରହୁଥିଲା ବର୍ଷା ଦିନ ଏଟା କେତେ ଦିନ ପରେ ହେଇଛି ଘଟଣାର ରିକଭରି
ରିକଭରି 5 ଦିନ ପରେ
5 ଦିନ ପରେ obviously
leading to discovery was on 5/9/1998.
occurrence 29
ଏଇଟା ହଉଛି ଆପଣଙ୍କର 29 ତାରିଖ ଦିନ
29 ତାରିଖ ଘଟଣା
ମାନେ ପ୍ରାୟ
6 ଦିନ ହେଇଯାଉଛି
6 ଦିନ ଖଣ୍ଡେ ପାସ୍ କରି
5 days after
ଅଗଷ୍ଟ ମାସର ମାନେ ସେ
ବର୍ଷା ଇଏରେ ମେଘୁଆ ବି ଥିଲା
ଶ୍ରାବଣ ମାସ ସେଗୁଡାକ evidence ବି ଆସିଛି that it was a rainy season. Witness has stated that.
And it was the knife was identified the doctor and also the
two witnesses.
Milord, sealing of knives is sealing of knives, Milord. After seizure, it was never sealed. It was immediately produced before the doctor, who had also
knife re blood nahi. That's one of the factor. But knife re kon pai blood nahi because it was in that year. But see, you are right that it should have been kept in the sealed cover. Question is that even if it has not been kept in sealed cover, it would have been very much material. Hardly blood stain would have been detected in. ତେଣୁ ବ୍ଲଡ ଷ୍ଟେନ୍ ନାଇଫ୍ ଇଏରେ କେବଳ ଦେଖିବା କଥା ଯୋଉ ନାଇଫ୍ ଟା ୟୁଜ ହେଇକିନି ସେ ଇଞ୍ଜୁରି ଟା ପସିବଲ କି ନାହିଁ ତେଣୁ ଦ୍ୟାଟ୍ ଇଜ ଆଭେଲେବଲ ଯୋଉ ନାଇଫ୍ ଟାକୁ ଏମାନେ ଦିଟା ୱିଟନେସ୍ କହୁଛନ୍ତି ଯେ ଆମେ ଦେଖିଲୁ ଏଇ ପର୍ଟିକୁଲାର ନାଇଫ୍ ଟାକୁ ଧରିକିନି ଦୌଡିକିନି ପଳଉଥିଲା ସେଇ ନାଇଫ୍ ଟାକୁ ଆଇଡେଣ୍ଟିଫାଏ କରିଛନ୍ତି ଏବଂ ଡକ୍ଟର କହୁଛି ସେଇ ନାଇଫ୍ ଦ୍ୱାରା ହେଇପାରିବ ତେଣୁ so these are the evidence in toto.
Just two facts I will bring to your lordship's notice. The lordship may kindly come to that presence of witnesses was why I am harping, my lord. Some facts were never discussed and never, my lord, it was completely ignored by the learned court below. Two facts, my lord. Firstly, it was the case of the prosecution that Natha dead, the father of the deceased, my lord, informed PW2 regarding assault by the appellant on the deceased. However, no answer was offered as to how Natha could know about the incident as the so-called eyewitness. Natha asi कहला PW2 को दे मो झियो को मार देछि प्रफुल्ल बोली. But it is PW2 who reached the spot first.
not a
what I am suggesting, my lord.
ଏଠି ହଉଛି ଆପଣଙ୍କର ଏତଲାରେ ଲେଖା ହେଇଛି ମୋର ବଂଶିକିଆ ଭାଇ ବଂଶିକିଆ ମାନେ ନିଜ ଭାଇ ତ ରିଲେସନ ପାତ୍ର ଆସିକିନି ମତେ କହିଲା ଯେ ତୁ ମୋ ଜ୍ୱାଇଁକୁ ଭୁସି ଦେଇଛୁ ଏଠି ନାଥ ପାତ୍ର ଯିଏ ଏକ୍ସାମିନ ହେଇନି ଡେଡ୍ ପାଇଁ he died, all right, he is not examined. ये କହିବା କଥା ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଆପଣଙ୍କର କଣ କଣ୍ଟେନସନ
Contention holds how could Natho know about the incident?
From
That-
where
that
he
is-
got the
that's the gap
information
now.
and how the
ନାଥ
statement ଅଛି।
ନାଥ
ନାଇଁ।
ଏକ୍ସାମିନ ହେଇନି ତା ଭିତରେ
ତା
ଆମେ
ଭିତରେ
କାଇଁ
ପଶିବା
ପଶିବୁ?
Now, what I'm suggesting, my lord, his case is that I was informed by Natho, but which cannot be believed. my lord.
Because-
ନାଥ ପାତ୍ର ସିନା ଏକ୍ସାମିନ ହେଇଥିଲେ
let us for the
ଆମ-
argument sake let us forget about the nath
ସେ ନାଥକୁ ଛାଡି ଦିଅନ୍ତୁ, ସେ ଯୋଉ ଆକୁ ବି ଛାଡି ଦିଅନ୍ତୁ, PW2 କୁ ଛାଡି ଦିଅନ୍ତୁ,
ଛାଡ଼ି ଦିଅନ୍ତୁ।
ସେ ଯାହା କହୁଛନ୍ତି ସେ ଆଇ ୱିଟନେସ କୁ କେବେ ଆପଣ
How
ଗେଟ
will you overcome that?
ସେ କିଏ କାହାକୁ କହିଲା, କିଏ ଆସି ପଛରେ ପହଞ୍ଚିଲା, ଆଗରେ ପହଞ୍ଚିଲା, these are all secondary things. Once you
Again.
don't place reliance on the two eyewitnesses account, ମାନେ ଯୋଉମାନେ ଦେଖିଛନ୍ତି, coupled with the ସେ ନାଥ examine ହେଲା କି ନ ହେଲା, ସେ PW2 କିଏ ଆସି ତାକୁ କହିଲା, these are becomes
Just I am questioning their
inconsequential.
presence in view of the evidence of PW13.
କାରଣ law is very clear that it is not the quantity of witnesses which matters, it is the quality of evidence. ସେଇଥିପାଇଁ କହୁଛନ୍ତି ଯେ ଗୋଟେ single witness ର version ଯଦି acceptable ହବ, true trustworthy ହବ, ତାରି basis ରେ ମଧ୍ୟ conviction ହେଇପାରିବ। ଏଠି ଦି ଜଣ witness କର version ରହୁଛି, medical evidence ରହୁଛି, ନାଇଫ୍ ସିଜ୍ ହେଇଛି, ନାଇଫ୍ କୁ ଦେଖିକିନି ଏମାନେ ଇଏ କରୁଛନ୍ତି, ଆଉ the manner in which the assault has been made and the internal injury is caused, ଯଦିଓ ଆପଣ କହୁଛନ୍ତି ଯେ ଡକ୍ଟର ଏଭିଡେନ୍ସ ଅଛି, of course court ରେ ଅଛି sufficient in ordinary courts of nature which
Court ରେ ଅଛି।
might not have been there in the
Postmortem ରେ ନାହିଁ।
but again you ଯଦି it can come within any of the clauses of that section 300 ର 300 ର ଯୋଉ 4ଟା clause ରହୁଛି, ଆପଣଙ୍କର ଏଇ ଯୋଉ sufficient in ordinary courts of nature ସେଟା clause 3 ରେ କହୁଛି।
C ରେ ଅଛି। ଆଜ୍ଞା, thirdly.
Culpable homicide is murder. The first if the act by which the death is caused is done with the intention of causing death. If it is done with the intention of causing such bodily injury as the offender knew or likely to be cause death of the person to whom the harm is caused. এই third রে আসুଛି ଯଦି bodily injury ଟା
Yeah.
it is done with the intention of causing such bodily injury and bodily injury intended to be inflicted is sufficient in ordinary course of nature to cause death. So ଆଉ ଗୋଟେ ଚାରିଟା ହଉଛି imminently dangerous. ତେଣୁ ଯଦି କୌଣସି ଗୋଟେ clause ରେ ମଧ୍ୟ ଆସିବ, even if the that is not there, then also it can be particularly you the weapon of intention ଟା ମଧ୍ୟ କେମିତି ଗ୍ୟାଦର କରିବ, ସେଟା ହଉଛି ଦରକାର ଯେ କୋଉ ୱେପନ ଆପଣ ୟୁଜ କରିଛନ୍ତି, କୋଉ ପାର୍ଟ ବଡି ସିଲେକ୍ଟ କରିକିନି ଆପଣ ମାରୁଛନ୍ତି, ଡେପ୍ଥ କେତେ ହେଲା, ପ୍ରି କଣ୍ଡକ୍ଟ ପୋଷ୍ଟ କଣ୍ଡକ୍ଟ, ଏ ସବୁ ଜିନିଷକୁ ଦେଖିକିନି ମଧ୍ୟ ଇଣ୍ଟେନସନ ଟାକୁ ଗ୍ୟାଦର କରିବେ। ଇଣ୍ଟେନସନ ଗ୍ୟାଦର କରିବାର ଗୋଟେ କିଛି ଷ୍ଟ୍ରେଟ୍ ଜ୍ୟାକେଟ ଫର୍ମୁଲା ନାହିଁ, ବିଭିନ୍ନ ଏଇ ଜିନିଷ ଗୁଡାକ ଇଏ କରିବେ। ତେଣୁ ଆପଣ ଯଦି ବ୍ଲୋଟା ଦଉଛନ୍ତି ଗୋଟେ ଭାଇଟାଲ ପାର୍ଟ ଅଫ ଦି ବଡିରେ ଏବଂ ଯୋଉଟାକ ଯୋଉ ପ୍ରକାର ଇଞ୍ଜୁରି କଜ କରିଛି ଆଫେକ୍ଟିଂ ଦି ଲଙ୍ଗସ, ଇନସର୍ଟ ହେଇଛି ଭିତରକୁ
ଲିଭରକୁ,
ତେଣୁ ଏଠି how do you say that this first clause is not satisfied? We are not going to the third clause. Death is caused with it is done with the intention of causing death. If the evidence is believed that your wife had come to attend the call of nature, right?
Okay.
You are coming to that spot with a knife, killing her, going away, concealing yourself inside the jungle till you are apprehended by the.
But what your lordship is suggesting, my lord, that particular part, that my wife had gone to that particular spot for easing her out, and the appellant came there. Had it been the normal course, then the intention could have been. For the first time and on the single day, she had gone there. There is the mirror problem. It is her first time to go there for easing out. Normally, she used to take. Again, এটা 2 কিলোমিটার বাট জায়গাটা তা ঘরু. There is a pond near her house where she used to ease out mirror. That is the evidence. Mother says that she used to.
it is spot it is not a disputed factor. Spot रे सही जगह रे घटना हेइची. Leave the केवल आई विटनेस को नांती अन्य विटनेस माने इंक्लूडिंग पुलिस रो इनक्वेस्ट मध्ये सही जगह रे तेणु आपण सेटू स्पॉट डिस्प्यूट करि परिबेनी.
Probably I am not clear mirror.
ना आपण जो कहउछे 2 किलोमीटर पई कोन ईजिंग करिकिन जीवो.
And how the appellant could know that on that specific day she will come there?
That depends because he has.
Intention is not there. But I am suggesting, but I had no.
Coming to from your house, you are coming to attack your wife who had
You are
gone.
following automatically they follow the wife from the starting point of because previous enemy quarrel and previous assault, and thereafter the lodging of the complaint. When it will come to the knowledge of the husband, definitely some anger will be there.
There is possibility. Who source ru asila
That
knowledge को ये अवश्य कहूची मु कहिनी
but my wife निजे भी कहि थाई पारे कथा राउ देछि बोली
जे मते बाडौथुलु मु देई देई
जाइछि.
तो तेणु who source रू पाइला माने तेणु एगुडाको सब becomes secondary once you
dislodge 4 and 5.
4 and 5 रो evidence.
चारि पांच को disbelief कले then you go other part.
And those things become minor things. Vital is the
4 and 5.
eyewitness अछन आपन को motive. That is it. That when the eyewitness account is clear, non-proving of motive is irrelevant. ହେଲା कौन पाई मारथिबो जे तम कौन पाई मारथिबो ये सबुटी मोटिव टा circumstantial evidence रे से माने कहउछन्ती the law is that motive रो गोटे importance होउची. You know,
but here it is
all and sudden किछि provocation आसे कि असल कल्ला कंगला different thing. But here that part is also there. Previous quarrels and
wife जदि 2 किलोमीटर आसीची ईजिंग करिया बा जो कोनोसी कारण पे आसीची तो कोन
is there and others have seen that he is flying out from the spot.
तेणु सीए ताकू फॉलो करिकिन आसीकिनी सेही जगह रे because he might not be knowing that others should be present at that point of time.
And the evidence of the mother that throughout the life he is torturing, he is assaulting the
सेटा मध्य 4/3 रे मध्य मेंशन है जे
that complaint.
जे ताकू बड़ा बड़ी करथिला बेली.
आग दिन स्टिक रे मारिछि बोली से रेखी देछि तापरे.
Yeah, don't rely decisions which have been given on rigor mortis. All those are based on this Modi's jurisprudence. But if you can go through the Google and typed it out, rigor mortis in how it varies, how can not be changed. You can find that latest you science तार ये रे सब अच्छी आदि रे जे केमती भैरी करिवो आपण कंसिस्टेंसी आसीबोनी के
आसीबोनी.
कोल्ड वेदर ये रे को जगह रे घटना आइची को प्रकार ये आइची भैरी करिवो. तेणु डॉक्टर जो ओपिनियन से गोटा देई देला ना पास कर जाइची तेणु ये घटनाटा आइची एते घंटा आपण ताकू नै किनी पूरा आर्गुमेंट करूचंदी से घटनाटा जदी अछि एटा तो 24 घंटा पास करनी तेणु एमाने ताकू देखि नथिबे ये घटना बहुत आगु रहिकिन डेड बॉडी वे तो पड़िथिबो सकाळू केतेबेल गोटा घटना हेतिबो ये तो डेड बॉडी देखिथिबे तेणु एई हिसाब रे आपण ये कहउचंदी किंतु again
because the Pedal 4 and 5 evidence is very consistent. And that has not been in the cross examination they have not
टाइम गैप भी नाही आपण घटना हबार police station distance which is 16 kilometers. Within 2 hours, the FIR has been lost.
To manipulate or to bring a new story to the
हाँ,
that is not possible in.
With all honesty, my lord, there is no way to dislodge these evidences, PW4, and they are consistent throughout.
but since it is time now, we'll
Monday.
dictate the judgment at on the Monday.
Yeah.
So both of you also again you just go
I will-
because
I will-
it's a live sentence. We are giving another opportunity to
am
you.
obliged.
Just go and also see about this rigor mortis for your satisfaction. We have already seen, and it has been dealt with because they have said that these particular things which you are stating, that also it is there that weather condition ଏଗୁଡାକ ସବୁରେ vary କରିବ ଆପଣଙ୍କର ଶୀତ ଦିନ କୋଉ ଜାଗାରେ ହଉଛି ଘଟଣା କୋଲ୍ଡ ଇଏରେ ଏଗୁଡାକ ସବୁ vary କରିବ ରିଗର ମର୍ଟିସ୍ ପାଇଁ ସେମିତି ଗୋଟେ ଷ୍ଟ୍ରେଟ୍ ଜ୍ୟାକେଟ୍ ଫର୍ମୁଲା ହେଇକି ଆଇ ୱିଟନେସ୍ ଆକାଉଣ୍ଟକୁ ଆପଣ ସେମିତି କେତେଗୁଡା ଜାଗାରେ ମଧ୍ୟ ଇଏ କରାଯାଏ ଯେ ଫୁଡ ଡାଇଜେସନ ଯେ ଆଜ୍ଞା ସିଏ କହୁଛି ଯେ ଘରୁ ଏ ଖାଦ୍ୟଟା ଖାଇକିନି ବାହାରିଥିଲା 9ଟା ବେଳେ ଯଦି 9ଟା ବେଳେ ସିଏ ଖାଦ୍ୟ ଖାଇଥିବ ତାର ଫୁଡ ଏଠି ଘଟଣାଟା ଏମାନେ କହୁଛନ୍ତି 11ଟା ବେଳେ ତେଣୁ 11ଟା ବେଳେ ଅନଡାଇଜେଷ୍ଟେଡ ଫୁଡ ଥାନ୍ତା ଯଦି 11ଟା ବେଳେ ସିଏ ମରିଛି ତେଣୁ ଯେହେତୁ ଏଠି ସେମିତି ଅନଡାଇଜେଷ୍ଟେଡ ଫୁଡ ମିଳିଲାନି ତେଣୁ ଏଇଟା ଜଣା ପଡୁଛି ଯେ ଘଟଣାଟା 11ଟା ବେଳେ ହେଇନି ତେଣୁ ଇଏ ବହୁତ ଲେଟରେ ହେଇଛି ସେତେବେଳକୁ ତା ଫୁଡ ଦ୍ୟାଟ ଅଲସୋ ଟେକେନ୍ ଆଜ୍ ଏ ଗ୍ରାଉଣ୍ଡ କହିଲେ ଯେ କୋଉ ଟାଇପର ଖାଦ୍ୟ ଖାଇଛ କୋଉ ଟାଇପର ଖାଦ୍ୟ ଖାଇଛ ତାର ବଡିର କଣ ଇଏ ସମସ୍ତଙ୍କର ଡାଇଜେଷ୍ଟିଭ ପ୍ରୋସେସଟା ସେମ୍ ନୁହେଁ କିଏ ଶୀଘ୍ର ହଜମ କରିପାରିବ କିଏ ଡିପେଣ୍ଡସ୍ ଅପନ୍ କୋଉ ଲୋକା ମାନେ ଏରିଆରେ ଘଟଣା ହଉଛି ସେଠି ଏଗୁଡାକ ତମେ ଡକ୍ଟର ଜଷ୍ଟ ଆସିକି କହିବ ଆଜ୍ଞା ସେମି ଡାଇଜେଷ୍ଟେଡ ଫୁଡ ମିଳିଲା ସେ ଏତିକି ସମୟ ଭିତରେ that's not the thing. If the eyewitness states in one way, you are to, if you want to dislodge it by the expert evidence, it must be of that standard and it must be backed by reasons also. ସେଗୁଡାକ ନୁହେଁ ଯେ ଅନଡାଇଜେଷ୍ଟେଡ ଫୁଡ ମିଳିଲା ରିଗର ମର୍ଟିସ୍ ହେଲା ତେଣୁ ଏତିକି ତାକୁ ଆମେ କାଲକୁଲେଟ କରିବୁ ଏଟା ମ୍ୟାଥମେଟିକ୍ସ ନୁହେଁ
Understand.
can by way of mathematics you cannot appreciate the evidence of the eyewitness. So we'll take up, Mr. We're making it part hard and it will come on the top of the list and
Monday.
ଏଟାକୁ ଲେଖିଦେବେ ହାର୍ଡିଂ ପାର୍ଟ କରିଦେବେ it will come on top of that hearing list, okay, on Monday also.
Well, pardon to mention, my lord, a very urgent matter lying before justice, division bench of justice D. Das, my lord. The urgency is that when the matter is pending before this honorable court, the authorities are evicting the petitioner forcefully by the help of the police, my lord. The very urgent, that's why I'm mentioning.
Do you mention before the, because now it is not the time to mention this.
Right now
That's
they're
it.
evicting, lordship.
Now
they are entered in the house and evicting, my lord.
It's all right that it has to be seen. Yes, that's
But nobody is there to help him, my lord. Sufficient.
you record of half.
Supplementary list item number 1
Wonderful.
Are you having this particular letter with you? Or that it has come?
Well,
The criminal appeal has been dismissed,
well,
and the appellant was on bail.
well,
So we pass a direction that he has to surrender within 4 weeks, and if he fails to surrender, then immediate steps shall be taken for his arrest to serve out the sentence. Usual order has been passed. When it was communicated to the concerned court, it was found that there has been premature release since 2012.
well,
So neither the London State Council brought it to our notice, nor the London Council for the appellant. So the question is that, and during pendency of the criminal appeal, no doubt you have got power for premature release. But question is that suppose thereafter the criminal appeal, it is not that merely because you release someone prematurely during pendency of the appeal would be infructuous, right? Because the conviction remains, right? So in spite of that, he may likely to continue the appeal. The or he may say, "No, I do not want to continue the appeal." My option lies with it. So now, when appeal has been dismissed and he has been prematurely released, the question is that whether he is to be recommitted to the, or our order, the order which has been passed, that will prevail over the order. That is the point. But while releasing prematurely, sometimes some conditions are imposed that suppose he could deviate from the condition, he can be taken into custody. Sometimes the conditions are imposed that your appeal is pending, but if the appeal result so desires, you can. So in this particular case, what was the any such condition was imposed while granting premature release?
I will take that instruction.
Because guidelines are there,
Well,
and we are told that at different point of times, different guidelines have been issued time to time. Latest has been issued in 2022, right? But the relevant date for taking into account that is the period, the date on which he was convicted, right? So as on that day, if whatever guidelines is there, that is to be taken into account. But if any subsequent guidelines comes and it relaxes that earlier guideline, so that whichever is advantageous to the convict, that will be taken into account. So here in this case, the appellant was found guilty, as it appears. The date of conviction was passed by the London Additional Session Judge on 5/4/2008. So whatever guidelines you are there, that you have followed. We are concerned with that whether any such condition was imposed that if the result of the appeal so desires, then you will be taken back. Thereafter, they may again release them prematurely. So that's a different matter. Question is that whether any such condition is there or not. So if it is not there, now whether he can be recommitted to the, so there is provision for recommitment in GRCO itself. So that will found that, but whether the provision of, suppose somebody is in jail, somebody is on bail, and appeal is dismissed, we pass the order, then there is a recommitment warrant is to be issued and he is to be taken into custody. Those provisions are there in the GRCO. So in this particular case, since premature release order has been passed, just look into that whether any such thing is there or not. And also the legal principle that, yes. Otherwise, you see, then if you prematurely release somebody, then there would be, if we decide the appeal and even if we confirm the conviction order, there would be no fruitful purpose, because even if we dismiss the appeal, he cannot be taken into custody. Then what is the purpose of deciding the criminal appeal? That is another factor it is to be taken into account. So that means the order which was passed during pendency of that will prevail irrespective of what would be the result of the criminal appeal. So what is the legal position? Number one. Number two, what is the your guideline is there or not? Maybe that there may be some kind of guideline that in such cases what is to be done. And in this particular case, what has happened? Whether, as we are pointing out, whether any condition, suppose somebody is prematurely released, tomorrow he commits another crime. So can the state express helplessness? Na dode, he has been released and so we can just put him. So the earlier sentence we cannot. So that is why the conduct is also to be paramount consideration. How he conducts after all these things are you examine it and we'll
because in most of the cases we have deferred. It is in this case that there was no concrete information before us. So we have to proceed and we'll dispose of.
You see, nobody informed us. He was on bail. So we continued the hearing and decided the appeal. Appeal was dismissed. We passed the order that he is on bail. He is to surrender within 4 weeks. Otherwise, he will be taken into custody in accordance with law. Now it has come to that he has been prematurely since 2012.
Yes.
So verify it and we'll take it till March.
March 1st.
1st March we are keeping it on.
Is it Friday?
Friday.
Yes.
So I will take you.
Yes.
The I should just that. Peruse the letter for peruse the letter of the letter dated 12/12/2022 of the Land and Special Judge Vigilance Balangir, from which it appears that the government of Orissa on 31/10/2012 में केबे रिलीज है लागी intimated regarding premature release from the jail order of this one influence 31/12/2000, right? That the appellant has been released prematurely after following due procedure. When we decided the appeal and pronounced the judgment on 15/11/2023, we not only dismissed the appeal but also directed the appellant who was on bail as per the order dated 22/8/2014 to surrender before the Land and Trial Court immediately, and further passed the order that if he did not surrender within 4 weeks, then the Land and Trial Court will take immediate steps for his arrest to serve out the sentence. The Land and Counsel for the state seeks some time to obtain instruction. It is pertinent to note that when the appeal was taken up for hearing, neither the Land and State Council nor the Land and Counsel for the appellant informed this court that the appellant has been released prematurely by the order of the government. Land Counsel for the state seeks some time to obtain instruction regarding the availability of any guidelines, oblique rules relating to the to deal with premature release, the effect of the premature release in during pendency of the appeal, if the result of the appeal so desires. The Land Council, you file that, let the law secretary file an affidavit to that effect. Let the law secretary file an affidavit to that effect. The Land Council for the state shall obtain specific instruction that whether any while releasing the appellant prematurely, any condition was imposed that regarding that if the result of the appeal so desires, he has to be again recommitted to prison or not.
My lord, it is IG prisons to file an affidavit, but law department, secretary law, it is IG prisons because they are with the premature release, my lord. So the affidavit should be filed by the prisons, IG prisons, my lord.
No, the law secretary
are
can
asking
highlight
for any rule
with
or-
any rule, etc. He might be aware about the same, because every state has different type of ours GRCOA recommitment, words have been used and how it is to be done. But so far as the persons who have been released prematurely,
But the conditions which are implied are not that portion, my lord.
that file would be there, na? Every convict's premature release, because you see the opinion of the court concerned is to be taken.
State council can take the consultation of the IG.
Uh-huh.
You can take.
The London State Council can consult the IG presence in that respect, and if necessary, the IG presence may also file an affidavit to that effect. Okay, so both affidavit will come. We'll decide because such type of problem may likely to occur in future, and in every case, it was also the duty of the state council. That means it should be intimated to the AG office, and while
where
placing
the
the
appeals
matter
are pending, the information should come to the AG office so that we can also.
Because once he's premature, he
Release
might not be interested to continue the appeal. He said that I will just withdraw the appeal. So
we'll talk, my lord.
right. But here we have already decided, we have not only dismissed, we passed that you have to surrender, otherwise steps will be taken. And now the London trial court has expressed that what I will do, because he has been, that was not brought to our notice, right?
Right.
Till the next date, the appellant shall not be taken into judicial custody for them. In pursuance of our in pursuance of the judgment and order dated 15/11/23, 15/11/20. Communicate the order to the London trial court immediately. Yes.
It will come on March.
On 1st March.
Let it be on March 15, my lord.
Okay. 15th March 2024. All right. You call both of them so that it would be for all time to come, this problem would be sorted out.
A free copy.
Free copy of the order. Yes.
Item number 2.
When the matter was taken up on 7/12, also nobody appeared.
It has already stayed, my lord. Yes,
okay.
One single copy has given, another copy I am giving, my lord.
So we are just adjourning this case.
Mallard.
Any date?
No, nothing.
All right. The Land Council for the state has produced the order dated 14/12/2023, passed by the Honorable Supreme Court in SLP Civil number 38701 of 2020, which indicates that notice has been issued and operation and implementation of the influence judgment has been stayed. Put up this matter. Put up this matter. April ଗୋଟେ ଡେଟ୍ ରଖିଦିଅନ୍ତୁ ହେଲା କାରଣ ଏଇଟା ଆସାଇନ୍ ହେଇଛି ତ ସେ ହଁ ଗୋଟେ ଡେଟ୍ ରଖିଦେବି ଶୁକ୍ରବାର ହଁ ଏନି ଫ୍ରାଇଡେ ରଖିଦିଅନ୍ତୁ ହଁ the order is taken on record କରିଦେବି।
During trial stage, the petitioner had custody in 7.5 years in NDPS case, madam.
What is the sentence imposed?
During trial stage, the trial was not yet completed.
Achha. Give the man. Yes.
Same thing.
Yes, madam.
ଯେ ତଳକୋଟ ପାସପୋର୍ଟ ରିଲିଜ ପାଇଁ ମୁଁ କ୍ରିମିନାଲ ରିଭିଜନ ଫାଇଲ କରିଛି ସେ ତ ଶାଶୁ ଭେଣ୍ଟିଲେଟର ଅଛି ସେଟା ହଉଛି ସୋମବାରକୁ ଆସୁ ଦିଥର ମେନସନ କଲି
Give the memo. Yes.
I don't mention my lord, an urgent bail application, specifically urgent to 16th January 20.
Pardon to mention, my lord. Worship, item 36 from today's list, my lord. Mr. Sahu has mentioned it before already, my lord. If that can be accommodated within item 36 from today's list, my lord. Mr. Jagavonsa has already mentioned in the last statement, my lord. If that can be accommodated today, my lord.
You want adjournment?
No, my lord.
Then-
If that can be taken up.
Okay, yes.
Pardon, my lord, lordship is fixed to January 2nd, my lord. Thereafter not listed, my lord. Urgent bail application, my lord.
Supplementary list, item number 1.
Has been convicted under section 326, 458 and 34 of Indian Penal Code. The Miller charge was framed under 458, 307, 380 and 34. Acquitted under section 307 and 380. Co-accused have been released out of 10 years for imprisonment, my lord. He has almost completed 7 years, my lord. And initially he was arrested on 34-14 and then released on 11-4-18. And thereafter, my lord, from the date of conviction is there. The custodian co-accused to, my lord, the other appellant. This is the order you will also pass. Yes. Also, can you turn to the incriminating material against me, my lord, there under section 27 of the Evidence Act? The weapon of the offense was recovered from my house, and it was not placed during.
It was not rejected on merit as yet.
No.
So as it appears, 326 it is 10 years.
10 years.
458 is 5 years.
5 years.
And the sentence are to run concurrently. So the maximum one is 10 years.
10 years.
So what is the period for which you are in custody?
I am custody, my lord, is 6 years, 7 months.
Have you got that custody certificate with you?
My lordship, kindly glance to order date 11th July 2023, lordship.
I filed.
That he has a 13 criminal antecedent, and my lord is directed to give a comprehensive.
I've given the comprehensive. Your lordship also had this matter in 12-12-2023 and expressed the opinion that let him be there till Xmas because the Puri man.
So what comprehensive affidavit you have filed?
I have filed, my lord, 13 evidence. I have given in tabular form. In fact, my lord, not 13, it is 12. As per police, the date it was given, my lord, it had indicated that on 15-12-2023 there is a case against me while I was in custody. In fact, my lord, prior to 15-12-2023, it was indicated that I am involved in a case.
What are these offenses you have not
Offenses,
mentioned?
my lord, or the police has given as per.
No. These 13 cases.
Yes, madam. 13 cases, almost, my lord, 379, 307.
Yes, Mr.
390.
My lord, that comprehensive affidavit we have.
No, comprehensive affidavit, nothing has been mentioned.
No, that 13 say we have given the copy probably in 4 cases. Not in the file, my lord. I had got it from the order sheet.
The police has submitted a report to the office indicating there are 13 cases. In fact, there are 12 cases.
It's all right, 12 or 13 does not matter, but what are the offenses involved?
Offenses, my lord, as per the report of the police, my lord, 394. First case is Puri Town PS 174 of 2008. That is under 379. I have been acquitted. Then Chandanpur PS 56 is the present case. Then 56 of 2010. That is 341, 323, 379, 34. And that also acquitted, my lord. Kumarpada PS case 64 of 11 307 and 2527 Arms Act.
So about this custody period, have you obtained instruction?
no.
Have you brought that custody certificate with you?
No.
So your case is that you are in custody for 6 years.
More than 6 years, my lord. I've arrested on 34/14 and released on 11/4/18.
In connection with this particular
particular-
case, because you have got number of cases. So
No, but in particular this case, my lord,
right.
it was indicated in
So you obtain instruction
Yes.
about that.
Your
Produce
lordship
the
order is
custody
very clear on 11/7. 11/7/2023, your lordship can have a glance. Your lordship indicated taking into consideration the instruction received by the state by them. He was
Friends,
released from
submitted, so
custody-
and so remanded, so and so thereafter the imposition. No, that was whatever you have stated, it has just been incorporated there. That you made a submission that
Yes, yes.
you have undergone more than.
I'll open it.
So IA number 2113 of 2022. अरे एगुड़ा का सामनारू हटाओ टिके. I'm not able to see your face. ये side गुड़ा हटाओ. Right. Learned counsel for the appellant submits that out of 10 years of substantive sentence imposed by the London trial court, the appellant is in judicial custody for more than 6 years. Since no custody certificate has been produced, let the London counsel for the state obtain instruction in this respect from the concerned jail superintendent. In which jail he is there?
Puri.
So take instruction. Put up this matter in the week commencing from 19th February 2024.
Item number 3.
Mr. Tripathi, you in that letter which you will address to jail superintendent, you should mention that in connection with this case, because if you will consider the other cases, that is one. Yes.
May I please? The appellant faced a trial and has been convicted under section 304 part 2 IPC for 10 years 20,000. There is 2 items of PW 8 and 9 is the allegation. Allegation as per the prosecution case, my lord, the appellant has a vegetable shop, my lord, and this is has taken rupees 36.
You are on bail during trial.
No, ma'am.
So since when you are in custody?
I am in custody since 8/12/21, ma'am.
So 2 years, 1 month.
2 months.
2 months. Okay. What is the name of the deceased?
This is name of the deceased.
Krishna Jhodia.
Huh?
Krishna Jhodia.
Krishna
Jhodia.
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 Jhodia. What is the date of occurrence?
Date was 6/12/21.
Cause of death?
Cause of death.
Cause of death is craniocervical cerebral injury and its complication.
Doctor, PM doctor is?
19.
9. The tomato tray, madam.
So who are the eyewitnesses to the occurrence?
PW 8 and 9, madam.
PW 1 and 8.
PW
1 and 8.
PW 1 and PW 8.
Yes, sir.
So what they have
9.
stated that how the assault took place, what is the weapon of offense?
Weapon of offense is tomato tray.
Tomato tray. Tomato basket, madam.
Okay.
That's injured on the head, man.
There was some quarrel,
Yes,
and in that tomato field, the occurrence took place or what?
Tomato shop.
No,
in the vegetable shop, my lord.
Vegetable shop.
my lord.
Okay, vegetable shop, the occurrence took place.
Yes, ma'am.
Tomato tray, he just picked it off and gave a blow on the head. How many days after the occurrence the deceased died?
Same
After
day.
2 days.
Same day.
Next day.
Next day.
Yes.
What about the criminal antecedent?
No, my
That part I have not accepted.
FIR registered fact 341, 323, 506, my lord. After death, my lord, case was converted to 302, and petition has been converted under 304, part 2.
That tomato tray has been seized and
Yes. Query
the
report
query
also.
made
Yes,
and
PW
it's
19.
possible by.
Right. That is in para 4 of PW 19 example.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner is in judicial custody since 8/12/2021, and as such, out of 10 years of substantive sentence imposed by the London trial court, he has already undergone 2 years and 2 months of sentence. He further submits that as for the prosecution case, while near a vegetable shop, there was exchange of hot words between the deceased and the appellant for money matters, and during such quarrel, the appellant dealt blow with a tomato tray bracket basket on the head of the deceased, for which he sustained bleeding injuries, shifted to the hospital, but died on the next day while undergoing treatment. The Land Council submits that there is no chance of early hearing of the appeal in the near future. Balance of convenience is in his favor. There is no criminal antecedent against the petitioner, and therefore the bail application may be favorably considered. Land Counsel for the state oppose the prayer for bail, place the statements of 2 eyewitnesses, that is PW1 and PW8. So also the doctor bracket PW19 conducted post-mortem examination and opined that the cause of death was due to craniocerebral injury and its complications. Land Counsel for the state submitted that the tomato tray was sent to the concerned doctor for examination and opinion regarding possibility of injury sustained by the deceased, and the doctor has given a positive report. Considering the submission made by the Land Counsel for the respective parties, the nature of evidence adduced during trial, the surrounding circumstances under which the offense has been committed, the period of detention of the petitioner in judicial custody, absence of any chance of early hearing, I'm inclined to release the petitioner on bail, allowed stay realization of fine.
Item 4.
May I please your lordship? My lord, here my lord 20 years conviction for the offence under section
May I please? I have annexed the requesting copy in the appeal memo in Annex 2. And the petitioner is convicted under section 22C of NDPS Act. And then the page 17, running page. Sentence imposed one short. Thereafter, my lord, custody period is 12/4/21 to 29/9/2023. Thereafter, I have filed appeal, my lord. Throughout the appeal period and trial period, he was in custody. My lord. And,
No, your arrest date is 12/4/2021.
yes, sir.
That means you have not even completed 3 years of sentence. So
About 3 years, 2 years, 9 months,
Um,
10
so-
months, 10 months.
So question is that if half of the punishment undertaken matter is different, but
And so,
So-
far the witnesses examined, my lord, the 3 witnesses examined only. PW, my lord, 3, PW 3, my lord, the IO, the issue that the sub-inspector of excise, and PW 2 is the, my lord, the Basant Kumar Barik, the constable and AB excise in Barampur, and the PW 1 is the independent witness. In several witnesses there, they have only examined, my lord, 3 witnesses. And the independent witness not supported the case, my lord, present case, my lord. And accused having no criminal antecedent. He has allegation that he was sitting in front of the vehicle while the contraband articles were seized from the Dala of the vehicle.
So how do you get over section 37 of the evidence NDPS Act? I have to give a finding that in spite of the conviction of the order passed by the Lennon trial court, there is no material that you are guilty of the offense and that you are not likely to commit the offense while on bail. So the official witness version can be also
Yes,
taken into account in a case of this nature, because in such type of cases usually the independent witnesses do not support the prosecution case.
Like,
So
my lord,
merely because they are police officials, so that cannot be a ground to disbelieve the prosecution case. You move after the that you half of the punishment is you undergo.
yes, true, my lord, at least, my lord, some period may be granted.
No,
At least, my lord, his mother is, my lord, bedridden and small
that you
child
can
is there.
file interim application
Small
at
child
any
is
point.
there, my lord. Some days may be
No,
granted, my lord.
if I take that ground, file a petition, if there is, we'll obtain report and then we'll consider your case. I'm just adjourning this matter,
Yes,
set of this matter in the month of April 2024. Yes, next. Yes.
Item 8.
May I please, Lordship? My lord, on dated 4/12, my lord, on my interim application, my lord says directed to take instruction.
That interim bail application on the ground that the appellant is suffering from cardiac problem and shifted to hospital.
My lord,
That was your contention.
my lord,
So what instruction you have obtained?
I missed it. Let it come on Monday, my lord.
No, Monday it will come on Friday. So
I will take instruction.
okay. Land Council for the state will seek some more time to obtain instruction regarding the health condition of the appellant as per order dated 4/12/2023, put up this matter on 16th February 2024.
Lordship, item 8, there is another matter attached to it. Lordship, let this matter also be
What is the number?
1346 of 2023.
Take it.
CRL
1346
46
of
of 2023.
ଲେଖିଲେ କି list this matter along with ଅଛି
That
କି?
is there. Take it.
ଅଛି ତ? There are some defects, Land and Council.
No, sir, I will remove in the
You
meeting.
have removed.
I will remove it
Acha.
and verify and remove.
ତାହେଲେ ସେଇଟା ଲେଖି ଦିଅନ୍ତୁ with ଲେଖିଦେବେ ତାପରେ then ୟା ଦେହରେ separate order କରିଦିଅନ୍ତୁ CRLA number 1346 of 2023 Land Council for the that matter might not have been also admitted 1346
Not listed for the first.
put of for SR after filing. Acha, you have not filed the certified
No,
copy
sir,
of the
I
input
have
judgment.
filed it on a.
Stop reporting जाएंगे defect remove कर देना.
I had filed it on 3/120. I will verify and I will do it.
ସେ ଅସି ଲାଗିଛି certified copy of the input judgment not filed ବୋଲି defect ଦେଖେଇଥିଲେ ସେ କହୁଛନ୍ତି ମୁଁ ଜାନୁଆରୀ ମାସରୁ ଫାଇଲ କଲିଣି ସେଟା ଆଟାଚ ହେଇଛି କି
3/120.
ଅଛି ଲେଖନ୍ତୁ defect number Land Council for the petitioner has filed the certified copy of the input judgment which is available on record. Hence, the defect number 4A has been removed. Land Council for the appellant undertakes to remove defect number 9. That are provision of law to mention kar deja within a week. Hard admit call for the trial court record. As a trial court record receive ही first one since the trial court record has already been received in CRLA number 1283 of 2023. The matter is attached to the said file. The trial court record need not be called for from the Land and Trial Court. You call for trial court record of কাটি দেবে এটাও লিখে দেবে তুমি. Yes.
Always.
अच्छा अच्छा এটা okay সেটা কাটি দিন certified but it appears that authentication fees of rupees 45.75 paisa to be paid on the certified copy of the input judgment. Hala? Land Council for the petitioner undertakes to remove the defect by Monday कर दो जी defect दे दियो था by on. So बाकी admit छोटा सब रहेगा. Yes, next. लिखी दो what a line. The registry shall place a note on the next date whether the two defects have been removed by the Land and Council or not. Hala? Yes.
Item 9.
I pardon my lord. I'm honored to appear before your honor due to a fracture of the leg. That's why on virtual mode I'm
Item 10.
May I please, my lord? My lord, on last occasion, my lord has directed the state to obtain audit report. And I have also filed the deposition copy of the informant and also the IO along with independent witnesses, my lord.
So what is there in that audit report?
Audit report is not available in the CD mirror, but the prima facie case was made out against this. This is a ABLPL petition. This I am reading the statement of one PW1. There are 16 charge-sheeted witnesses. Out of them, 12 have examined so far.
No, that is that co-accused is facing trial.
Yes,
Because he is an
yes. I am reading that statement of PW1. Para 2. The accused Sachin Pradhan and Savitri Pradhan, this petition Savitri Pradhan, worked in our financial company, handled the customers by keeping the gold in the safe locker and handed over cash for the same. I made entry for the transaction. In the month of January, February 2022, auditor namely Ranjan Kumar Samtar made audit in our company and found 21 packets shortage of gold out of 32 packets and 7 packets are spurious.
that other person is in custody or on bail?
Custody.
My lord,
The other person, Sachin Pradhan,
Sachin Pradhan.
is in custody.
He is now on bail.
Huh?
He is now on bail.
Bail means interim bail or regular bail?
On regular bail, my lord.
Where is the bail order copy?
No, I don't have that copy, but I got the instruction, my lord.
Get that copy. We'll take up this matter next week. The Learned Council for the why are you not getting that audit report? He says that
there are, I am telling you, the locker contains 2 keys. One is with this Sachin Pradhan and another is with Savitri Pradhan. When 2 keys enter into the locker, then the locker will open.
That is, you are right, but during the course of audit, what has been done, how he says that there is a finding of the auditor that
this packet is missing.
No, he took the responsibility that I have committed this crime.
The 2 keys are there.
May I submit, my lord?
One person cannot be.
That is the reason why what is there in that audit report. First see that.
Yes, my lord, I will.
Why such the auditor has stated that it is to be recovered, the entire amount is to be recovered from this.
Auditor was examined, my lord.
Yes.
PW.
What he has stated?
PW11, my lord.
So let us see that evidence.
Yes.
Where is that auditor has stated that the entire responsibility is of the other accused Sachin?
My lord, may I read it, my lord?
Yes.
Yes, my lord. The accused, namely Sachin Pradhan. P11, my lord. PW11. Para 2 poduchu, my lord. On dated 5/2/22, I came to Manapuram Asset Finance Limited for audit. At that time, accused Sachin Pradhan was acted as branch manager. On audit, I found 32 packets of gold were misappropriated, out of which 21 packets were missing, 7 packets mismatched, 3 packets of item changed, 1 packet 100% item changed. The accused, namely Sachin Pradhan, admitted his guilt in presence of me and other staff, namely Ajay Lenka, Savitri Pradhan. ଏମାନଙ୍କ ସାମ୍ନାରେ ସେ କହିଲା.
ଠିକ ଅଛି, ପଢନ୍ତୁ ଆରେ.
My lord. And Badal Samir Kalia. On dated 22/2022, I reported the same to area head office and audit head. The above said packets were seized by police in my presence. This is my signature.
My lord, may I read the IO version?
So if that Sachin has been released on bail, so you surrender and move for bail, the claim of parity is to be taken into account. As per the evidence of this auditor,
My lord.
your case stands in a better footing, as you said.
Yes.
So you surrender and move for bail. I've heard the learned counsel for the petitioner and counsel for the state. During course of hearing of the bail application, learned counsel for the petitioner submits that the co-accused Sachin Pradhan, who was the branch manager, of Mannapuram Asset Finance Limited at Nachuni branch, has been directed to be released on bail. And as per the evidence of the auditor, who has been examined in the trial court as PW Kete 11, the said accused admitted his guilt in presence of the petitioner and others. And the petitioner is a lady, and she may be permitted to surrender in the court below and move an application for bail, and claim of parity be taken into account. Learned counsel for the state has no serious objection to such prayer. Considering the submission made by the learned counsel for the respective parties, this anticipatory bail application is disposed of with observation that in case the petitioner surrenders before the learned JMFC Banpur in so-and-so case within a period of 4 weeks from today and moves an application for bail, the same shall be disposed of on merit, preferably in the first hour, and claim of parity with the co-accused. So also the proviso to section 437(1) CRPC shall be taken into account while adjudicating the bail application. In case the bail application is rejected, the record shall be sent to the Court of Session in order to enable the petitioner to move the higher court on the very day. And if any bail application is filed in the Court of Session, the same shall be disposed of expeditiously. Case record shall be made available. Yeah.
Obliged, man.
Item 11.
Yes, Mr. Mishra.
May I please, Your Lordship?
You are for
My
the
Lord, the
OP let's copy not served, Your Lordship.
OP. My Lord, previously, कितने number item कहले?
11.
हाँ. Previously, Mr. Malik was appeared,
Yes. My name is.
and I have served the copy to him. And in the meantime, informant expired since long. And he has also objected my interim application. Now, my Lord and friend has come said that.
No, you are appearing for whom?
Sir, my name is also there, and Mr. Malik instructed me that no copy is served.
No, the informant has died.
Yes.
So virtually,
in the IA University.
IA, no, I am not pressing that IA.
he is not facing that. Like on IA number so and so, this is an application for interim bail and counsel for the Petitioner does not want to press this interim application. Accordingly, IA is disposed of.
But Chief, item 14 may also be taken
Same,
together
14,
with this.
14A.
All right, so it's a case under section 302. Suppose the Mr. Malik was having power for the informant. Now the informant is dead. So you can appear, file wakalatnama for any victim. That means any family member. You can oppose the prayer for bail. There is no problem. But you cannot now up because he's a dead man now. So take that instruction if you want to, and the copy has been served. That's a different matter. So if you want to object, you can object. There is no, but there should be proper appearance in view of that statement which has been made that the informant is dead.
My lord, may be a similarly situated person, your lordship has enlarged them and
No, they may oppose. Now I cannot give them an opportunity to because
Let
of
them-
this.
let them
BLAPL number 9518 of 2022 list this matter along with BLAPL number. Which number go through? 2383 of 2023. That is item number 14. Learned counsel for the petitioner submitted that IA number set of the interim bail not feasible. That he has instruction that the informant is dead. Informant na likhi diyo. Informant na Ramakanta Baral is dead. Land counsel for the informant submits that he may be given some time to obtain instruction in that respect and file a VNAMA for any victim of this case to oppose the bail application. And the matter may be taken up next week. As
Just one more thing, your lordship, co-acquit person to release. So, dekhi diyo hame similar.
All right.
Giving
Yes. Put up this matter in the week commencing from 16th February 2024.
16, my lord.
Friday ଆସିବ ପରା matter of Friday also. You will not be available.
19,
Then it
my
will
lord.
go on to 23rd. Today is 9th.
Yes, my lord. 19, 16, my lord. I have
These matters cannot come because these are tied up matters. It is coming on Friday.
23, my lord.
Put up this matter on 23rd of February 2024. Land counsel for the petitioner submitted that similarly situated co-accused, namely
Lalit Mohan Baralo and Malaya Kumar Barik.
Dijono.
Your lordship has enlarged. And another person.
Some of the co-accused persons have been released on bail, and the bail order copies have been handed over to the Land Council for the state. Let the Land Council for the state examine the claim of parity.
I am also giving the deposition copy.
The deposition copies of witnesses examined so far in the trial court
Yes.
have also been supplied to the Land Council for the state. Yes. So it will come on 23rd February 2024 along with item number 14.
Item 12.
May please.
Yes, Mr. Samantray.
My lord, last occasion your lordship was directed to get instruction about the affidavit filed by the petitioner release on bail, my lord.
Last order was on 15/12/2023.
On 30th 6 2023, your lordship was directed to file affidavit that for two local securities who
Right,
were interested.
that you document you supplied
Yeah,
to the
yes.
London State Council,
My lord.
and he has to
Get
verify
instruction.
them. Yes, so what is it? This man petitioner is a man from which area?
It's from
Which
UP, my lord.
UP.
UP. 4 years already lapsed. He's in custody since 9/2/2020.
The report is that they are not willing to take you on bail. To provide some names and documents of some other sureties who are interested to Lekon. The Land and Council for the state has produced the written instruction received from IIC Ulunda Police Station dated 9/2/2024, from which it reveals that the local sureties are not willing to take the petitioner on bail. Land Council for the petitioner seeks some further time to provide the names, documents of two fresh local sureties to the Land Council for the state for its verification. Put up this matter in the week commencing from 26th of February 2024. Yes, 8 of them.
Item 13.
Yes, Mr. Naik.
And the petitioner is in custody, my lord, since 7/9/2020 for the offense under
Is very
section.
available?
My lord, CD is there in a connected matter. We still yet to get that file, your lordship. My lord, your lordship had directed on the last two occasions to get the address verification of the appellant, your lordship. We yet to
Yes.
receive that instruction, my lords. I pray one last chance of 2 weeks may be granted to me, my lords.
2 weeks is too much, man, because your lordship, this matter is lingering since long. It is in custody. Custody since, my lord, 7/9/2020. Co-accused person will release on
The
bail.
order that was passed,
Lordship.
that was on August 2020.
Yes.
My lords, 18/8/23.
So then it again came on
8/12.
15/9/2023. Then again came on
Yes.
8/1/2023.
And he is in custody, my lord, since long.
And so ଆପଣଙ୍କୁ ଯଦି ଅଗଷ୍ଟ ମାସରୁ ଆସି ଫେବୃଆରୀ ହେଲାଣି ଆପଣ ଆଡ୍ରେସ ଭେରିଫିକେସନ କରିପାରିଲେନି a man from UP, and there was a specific direction that the superintendent of police of Gajpati shall make necessary communication with the superintendent of police of Harthas in the state of UP.
Lordship.
So whether that communication has been made or not?
Lords, I have communicated to the SP today itself. I'm yet to receive any instruction, my lords.
No, that cannot be the ground. Person is in custody and
Since
you have
20.
been,
My humble submission that must have been made. I'm praying for next week, my lords.
and what about the local surety? Have you
Local
supplied
sureties
it?
have not been supplied.
We have complied. We have come from.
You have
from
given
our side,
the.
we have given the address.
So what about that? Or that you have not been also obtaining?
Compliant to boil.
ଆପଣଙ୍କୁ local surety ଙ୍କର ନାଁ address documents ଦେଇଛନ୍ତି ନା
No,
ନାହିଁ?
that is not part of my brief. No.
Mr. Counsel,
ଦେଇଛନ୍ତି।
My lord, I have submitted to the court and also
court ଦେଲେ କ'ଣ court ଯିବ verify କରିବ?
submitted copy.
Give the learned state counsel so that he will obtain instruction through the IAC. Land counsel for the state submits that as per the order dated 18/8/2023, he is yet to receive instruction regarding address verification and stop. The Land and Council for the petitioner has provided the names. Achiti dauchandi aji?
Yes, I've received, my lord.
Names,
Yes,
address and documents. Sab guda dele to se patta tara Aadhaar card guda sab deichan to. Okay. Documents of two local sureties. And council shall obtain instruction about the genuineness of the bailers and the authenticity of the documents. Put up this matter on 23rd February 2024. No further adjournment shall be granted to the Land Council for the state. Free copy of the order be handed over to. Yes.
Documents are in the court, my lord.
Hard Mr. Dharanidhar Naik, Land Senior Advocate for the petition. Yes.
Item 15. And while rejecting the first bail application, my lord had directed the learned trial court to conclude the trial by the second quarter of 2023. But my lord, still the trial is on initial stage.
Okay, the trial court has reported, this is the report dated 8/1/2023. And it's the report that out of 13 charge sheet witnesses, 7 witnesses have been examined. And 1 witness has expired. So the remaining 5 witnesses were to be examined. That is the report of 8/11. So the next date was on 16/11/23. So what happened thereafter?
My lord, I'm not aware about the trial court process.
So then,
But as per the instruction,
because only 5 witnesses are there, we examined, and the date was fixed to 16/11. In the meantime, more than 2 months have already passed. All right, I'm keeping it to the next week. You just ascertain that what is the position of the trial.
please, my lord.
Okay. Peruse the status report submitted by the London Trial Court, which is dated 8/1/2023, from which it appears that out of 13 charge sheet witnesses, 7 witnesses have been examined, 1 witness has expired, and the date was fixed to 16/11/23 for trial for the examination of the rest of the 5 charge sheeted witnesses. When a query is made to the land counsel for the petitioner about the status of the case, she seeks some time to obtain the same proved of this matter on 16th February 2024. Heard Ms. Kiran Pandey, Land Council, appearing through virtual. Yes.
Obliged, my lord.
Item 17.
May I please observe?
Yes.
Also, charge sheet submitted under section 21C, 25 and 29 of the NDPS Act, your lordship. This is the second bail application. The earlier bail application was disposed of as withdrawn on 13/3/2022 by BLAPL number 928 of 2021, your lordship.
It was withdrawn.
Yes, your lordship.
So now you are in custody since when?
Since 8/11/2020, your lordship.
Lordship, may kindly have a glance at order dated 11/10/2023.
11/10/2023,
my lords.
No, 10/11/23. That is, or 11/10. No, 10/11. 10/11.
There are 4 criminal antecedents against this bill.
Apart from these 3 criminal antecedents, your lordship.
And what are those cases?
That cases, lordship. One is under Kumbharpada PS case number 230 of 2019 under section 341, 323, 325, 294, 307, 506, 34 of IPC, your lordship. And second is same Kumbharpada PS case number 119 of 2020 under section 399, 402, 307, 323 IPC, reduced section 25, 27 Arms Act. And third was Baseli Sai PS case number 250 2020 under section 21C, 29 of the NDPS Act, your lordship.
So another NDPS
similar antecedent, your lordship.
So is a brown sugar commercial quantity.
Yes, or 256 gram seized from the petitioner and other accused person also.
Another case is also brown sugar.
Yes, sir. On that case, he was on bail, your lordship.
What day? In which case? The other case?
Yes, your lordship.
So you are granted bail in a commercial quantity of brown sugar, and then again you are involved in this case, and from your possession that was found.
Seized from the car, your lordship. And one pillion rider, Ravi Charan Mahanti, was granted 3 months interim bail by your lordship on 10/11/2023. This is the order, your lordship.
What is the status of the case now?
Out of 23 charge sheet witnesses, 5 witnesses have been examined, your lordship.
So let the status report come. You will see that the London Council through set up bail order copy to the London Council for the petitioner submitted that out of 23 charge sheet witnesses, 5 witnesses have been examined,
and the petitioner is in judicial custody since 8/11/2020. है ना? He further submits that similarly situated co-accused, namely
Rabi Charan Mohan.
Rabi Charan Mohanty, has been granted interim bail for a period of 3 months on the ground of delayed disposal of the trial. Copy of the bail order has been handed over to the Land and Council for the state info. Let a status report be called for. Matter be placed on 23rd February 2024.
Obliged, Lord.
Item 18.
May I please, Your Worship? Offender 302, 34 IPC, and in the meantime, my lord, out of 36 charge sheet, nobody has been examined, my lord. A petition since custody since 30/12/2020, my lord.
Date केबे custody?
30/12/2020.
So what is the total number of charge sheet witnesses?
36 witness, my lord.
Charge frame केबे हिची?
Charge frame
जानना थी.
ना जाने.
So not a single
your-
witness has been examined.
No, my lord.
And
And
here also
the
the bail petitioner has 3 CA against him, my lords.
That you have filed the comprehensive affidavit.
No, my lord.
You file it and we are
And
taking that.
your lordship, last time directed to dispose of the application within 8 months.
It's all right. Just I have to verify whether your submission that not a single witness has been examined is correct or not. That's
Yes.
I have to, because you are not producing the bail or that order sheet copy of the Land and Trial Court. The Land and Council for the petitioner submitted that the petitioner is detained in judicial custody in connection with this case since 30/12/2020. And even though charge has been framed, but out of 36 charge sheet witness, not a single witness has been examined. Land Council for the state, on the other hand, submitted that there are 3 criminal antecedents against the petition. Put up this matter on 23rd of February 2024. Let a status report be called for from the Land and Trial Court. Baki usual order kar debe. Land Council for the petitioner shall file a comprehensive affidavit relating to the status of the criminal antecedent. Yes, next.
Item 19.
Please, my lord. My lord, here the petitioner is languishing in jail custody since 31/12/2016, basing on an unknown FIR. My lord,
31/12/2016.
16. And that there was an omnibus allegation against 3 accused persons, whereas 2 of them have already been granted bail.
Just
So far,
status report we called for. Okay, status report asla.
out of 10, 2 of them only has been examined.
Again, the 3 accused persons, so and so. All right. Charge sheet has been submitted. Charge was framed on 6/4/20. In the meantime, 5 witnesses have been examined by the prosecution. Accused petition persons filed a petition under section 311 CRPC to recall PW 325 for cross-examination, which was allowed, and the date is fixed to so and so 14/12. So, what is the total number of charge sheet witnesses?
10.
So what do you say, Mr. 2016
Lordship.
ଲୋକ ରହିଲାଣି ଆପଣ?
Lords, his confessional statement is there, Your Lordship. And under
No, we are not on merit, but when the man is detained in, you see, 7 years ହେଇଗଲା 2016 ଡିସେମ୍ବର 31 ତାରିଖରୁ ସେ ରହିଲାଣି। ଆପଣ 7 ବର୍ଷ ହେଇଗଲାଣି ତାକୁ 5ଟା ୱିଟନେସ୍ ଏକ୍ସାମିନ୍ କରିଛନ୍ତି ଏପର୍ଯ୍ୟନ୍ତ। ଟୋଟାଲ ନମ୍ବର ଅଫ ୱିଟନେସ୍ ହଉଛି 10, ସେଥିପାଇଁ ସେ ବେଲ୍ ଚାହୁଁଛନ୍ତି। And he is a local man or outside?
Local man.
Any other criminal antecedent against him?
Oh, that is not there in the record, my lords.
Date of custody upon charge sheet achi ko?
Yes, charge sheet is there.
That please verify that date again. Because the FIR is dated 31/12/2016.
I got the charge sheet copy.
ଦେଖେଇଲେ ତା ଦେହରେ ଅଛି ଯେ ସେଇଦିନ ଆପଣ ଯୋଉ ଦିନ FIR ହେଲା ସେଇଦିନ ଆପଣ କଷ୍ଟଡି କି ନେଲେ। या ना कौन? पवित्र प्रधान।
Pavitra Pradhan, my lords. Yes, on 31/12/2016, my lords.
He was arrested
He was
and
arrested.
forwarded on the next day.
Lordship.
So, ଯାହାହେଲେ ବି 6 ବର୍ଷ ହେଇଗଲାଣି ନା?
Lordship.
Are the land and counsel for the petitioner, land counsel for the state. Considering the submission made by the land counsel for the petitioner that the petitioner is in judicial custody since 1/1/2017 and he has been charge sheeted under section 458/302/34 of the Indian Penal Code. And after going through the status report of the case submitted by the land and trial court, from which it reveals that out of 17 charge sheet witnesses, only 5 witnesses have been examined so far. In view of the delayed disposal of the trial, after hearing the land counsel for the, and since the petitioner is a local man, after hearing the land counsel for the state, I am inclined to release the petitioner on bail, appear before the land and trial court on each date when the case would be posted for trial. Allowed.
Item 20. May it please, my lords.
Yeah.
My lords, this is the third journey of the petitioner, my lords. I'm in custody since 22/7/2019.
22/7/2019.
Earlier, your lordship was pleased to grant me interim bail for 3 months, while order dated 16/9/2022. The case is one of
That is in real appeal number?
My lords, that is in BLAPL number 6414 of 2020.
Have you got that copy of that order?
Yes, my lords.
Finally. You have got the case date, no?
My lords, case date.
Mr. Panda, this ST case number is 2021. That means how many witnesses have been examined?
That's all total. Now 8 witnesses. I have also submitted the copies of the depositions to
What
me.
is the total number of witnesses?
42, my lords.
You have received the copy of the deposition of 8 witnesses. What they have stated?
Lords, in this case, your lordship, the dead body has been recovered, my lords. After a lapse of, my lords, 7 years, my lords. So PW1, your lordship, is the informant of this case, my lords. He is stating that her mother was missing from 9/6/2011. And then on December of 2018, she received an anonymous phone call that from the village of this present accused, my lords, that the mother has been murdered since 2011 and advised her to inform the police. Accordingly, my lords, she informed the police, my lords. She has also stated about the possible motive of this present accused because this accused person had taken gold ornaments and some money, my lords, from the mother, your lordship.
Okay.
Now, your lordship, as per the case diary, your lordship, there are 3 more evidence coming up against the present accused. One is he was last seen with by witness Sanjeev Panda along with the deceased, my lords.
Case based on circumstantial evidence.
Circumstantial evidence.
So last seen witness to be examined, as
Yes,
you said.
last seen on 13 or 14/10 of 2011. That this accused person was taking her to some place.
13th or 14th of November,
October, Your Lordship.
October 2011.
11, my lords.
When the dead body was found.
Dead body
It
was
was in
found.
the year 2018, my lords.
How do you correlate it to be last seen? So if a time gap is such, if it would have been,
She was missing from that period, is what I'm saying.
how do you say with certainty that thereafter she has not come in contact with anybody else?
She has not come in contact with.
No, you have not adduced the evidence to that effect.
Lordship.
Last seen would be relevant only when
My lords.
the two persons are seen and immediately thereafter the dead body was found, and that was also near the vicinity of that place. Not that somebody would be seen at Cuttack and after 5 days his dead body would be found at Bhubaneswar and that would be taken as a last seen. So the proximate links should be there.
My lord.
So here there is a gap of, as you said, 7 years.
Yes.
December 2018, it has been stated that the informant.
So that is one piece. What about the other things?
The other that is that he has confessed before two my lords,
extrajudicial confession.
Extrajudicial confession.
Okay.
And he has also confessed before the police, my lords. That's the third thing, which led to the discovery of the dead body. Only bones of which have been recovered, my lords.
So now these witnesses have been examined, 8 witnesses,
Lordship.
except PW1, what you said.
My lords.
What other witnesses have stated? I say deposition
Well,
copy.
let's have handed over a fresh set of deposition copies.
My lords, these witnesses are yet to be examined. These 3 witnesses I stated before your lordship.
PW2. PW2 is the assistant professor in the Department of FMT, Millets. The opinion is at page number 2 of the. The skeletal remains examined appear to be human in origin. However, all the remnants may be sent to SFSL Bhubaneswar for species identification test if the age is the third point. The individuality of skeletal remains could not be determined from the available contents. The time since death was more than 1 year of the time of examination. So, if the story of the PW1 informant is believed, Millers, that her mother, if your lordship may see the evidence that has come up, PW1. I'm reading para 2, Millers.
No, this Mr. Mishra, this
Lordship.
particular line has its importance.
My lords.
So if the death took place 1 year prior to his examination, that means it took place maybe that it is 2018 July.
No, he has stated more than 1 year.
মানে 2000 death took place more than 1 year at the time of exam. মানে 2018 পূর্বରୁ তা মানে ইয়ে হয়েছে।
But yes, PW2 has not identified completely, my lord.
So how
I'll
you
admit.
establish that skeleton to be that of the deceased? Who are else? If this doctor is not there, anybody is there to identify that this is the skeleton. Otherwise, the recovery becomes inconsequential. The skeleton was recovered unless you connect it to the deceased of this case. And how that skeleton recovery would be relevant? All right, heard Mr. Sudipto Pandal and counsel appearing for the petitioner and counsel for the state. The land counsel for the petitioner submitted that the petitioner has been granted interim bail twice.
No, Millets, once.
Once,
Millets. Earlier
once
it was
by this
rejected.
court in BLAPL number 6414 of 2022 as per order dated 16/9/2022. And after availing the same, you surrender at right time. Surrender at right time.
And for that reason, your lordship had called for a report also, which your lordship had gone through. On 19/10/2023, your lordship had reflected.
And in that respect, the report of the Land and First Additional Session Judge Sambalpur is very much clear. The Land Council further submits that in the trial court, out of 42 charge sheet witnesses, 8 witnesses have been examined and no clinching evidence has come on record against the petitioner. And in view of the delayed disposal of the trial and the conduct of the petitioner in complying with the earlier order of this court for interim bail, the bail application may be favorably considered. Land Counsel for the state, on the other hand, placed the evidence of the witnesses and submitted that it's a case based on circumstantial evidence and witnesses to the last scene, extrajudicial confession, and leading to discovery of the dead body are yet to be examined in the trial court. Considering the submission made by the Land Counsel for the respective parties, nature of accusation against the petitioner, nature of evidence adduced so far in the trial court, conduct of the petitioner in complying with the earlier order of interim bail, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail subject to condition that he shall not try to tamper with the evidence, appear before the Land and Trial Court on each date when the case would be posted for trial. Violation of any terms and condition shall entail cancellation of bail allowed.
Deeply obliged.
Yes. Oh, time is like next week re pure do Friday sabuda matter. God bless you.